Good morning, good morning, good morning. It's good to see, or as Letitia says, good morning. Good morning, everybody. Mike, 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 Mike. Guess what day it is? Hump day. Happy Wednesday, everybody. I hope you're having a good morning so far or evening, depending on where you're at in the world. I wanted to come alive a little bit early because I wanted to go over or talk about some of the things that happened yesterday during testimony and, just talk about them a little bit before we get started. And, also I wanted to let you guys know, for those of you that have been following the Madeline Soto case, Stephan Sterns has a hearing today in his CSAM case. That case is scheduled to go to trial February 24th, 2025. Um, I think that it's most likely going to be continued. I don't think that the trial is going to start on February 24th. However, if it does, I will cover it. I have followed that case. I was in that. I still am. I am incredibly invested in that case. It happened not that far from me when I was living in Florida. Obviously, now I don't live in Florida, so now it's real far, far away. But it wasn't at the time. Um, I'm I'm also invested in that case because both cases, there's 2 cases against him. He'll have 2 trials. I don't know, and I because I can't remember right now off of the top of my head, um, if Mr. J from Sarah Boone, if Lord, Jen, get it together. I don't know if Mr. J, who prosecuted Sarah Boone, is prosecuting Stephan for both cases. I know for a fact and for sure that he's prosecuting Stephan in the murder case. So, if there, when I know any updates on how that preliminary hearing went, I will let you guys know, obviously, because they filed some ridiculous amount of motions, like 30 plus. Um, Actually, we have a little bit of time. Let's go over to the Orange County Clerk of Court. Let's not now, Google. I appreciate you trying to help me, but I don't need to use my precise location. Oh, thank goodness. Let's see. Hmm. Hang on just a second. It might not be. Hold on. Sorry, you guys. It says Orlando. Let's see. All right, hold on. Let me look at this real quick. Bro, what? It is Orange County, is it not? Am I crazy? Hold on, let me just Google it like this. No, I clicked exactly what I meant. Yeah, this is oh my stars, what's wrong with me today? Anyway, let me see if I can't. Yeah, it is Orange County. That's what I thought. But for whatever reason, his his case, let me hold on a minute. Make sure that I'm spelling it right. Okay. All it's all that it's coming up with is like his civil cases. Hold on a minute. Let me see what I've done. Hold on a minute. Hold on. Let me just do it like this. Because I don't know what the deal is doing. I don't know what this site is doing. All right, let me try it like this. I'm sorry, you guys. This is what happens when you're not prepared. You are in a rabbit hole in your brain. Yeah, it's only pulling up his criminal case or his civil, like his civil traffic and just traffic stuff, not his criminal case. And I'm not exactly sure what's going on. Well, Michelle, I was looking into Stephan Sterns because he has a hearing today in his CSAM case, and his attorneys filed a ton of new motions. A lot of it is motions to suppress certain evidence, specifically like the Google searches or his Google stuff. So I was trying to see like what all those motions are and talk about them with you, but for whatever reason, um I can't pull them up. It's not pulling up his criminals, like his new criminal stuff. It's pulling up, or it's giving me like just like any traffic cases that he had. It's not letting me look at his criminal stuff, and I'm not exactly sure what is going on. So, let me look. Let me just do this. All right, let me try this. See if I can do it like this. Yeah. Uh-uh. Yeah, that's so weird. They're just his traffic stuff. Hmm. I'll try it. I'll keep working on it during the break. Um Yeah, well, that's what I was trying to update everybody with, Michelle, is what is going on with Stephan and what motions he filed. And usually Florida's pretty open about that. So normally I will blame everybody. I mean, I don't really blame everybody but me, but normally when I'm looking stuff up and I can't find it, it's usually due to um, the hold on a minute. It's usually due to like it's just not there, right? It's not usually a Gen Lu error. But this time it might actually be a Gen Lu error, and I'm not exactly sure what it is. And I don't want to waste you guys' time because that's rude. Um, and I don't want to be rude. Hold on, let's see here. But I did want to talk a little bit about the um testimony we heard yesterday in from the medical examiners. And because I was thinking a lot about it, particularly around the leaves. Okay. And um before I forget, I just want to say, Neat, um, You never did text. I don't know if you forgot or what the deal is, but you never did text so that I can save your number. Um, okay, so around the leaves. One of, I believe, one of or part of, I should say, the defense's theory about what happened with Evelyn is that she was moved, that she uh, wasn't always in that trash can. She wasn't always in that trash bag. And I think that the defense is using the fact that there were leaves found in Evelyn's hair to support that fact. I will say this. If I hadn't seen the state of that trailer, I might be inclined to say, okay, I can kind of see where he might think that, right? However, given the state of that trailer, because I think most people believe, including myself, that that Megan killed Evelyn in the trailer, put her body in the trash can, and then put the trash can in the playhouse. Okay. It is very possible that those leaves came from inside the trailer, but it is also possible that Megan may have wrapped Evelyn's body in the playhouse where there were leaves on the floor of the playhouse. That's also possible. Um, and so I don't think that the leaves alone would support the defense's theory that she was moved in some way, that Evelyn was moved in some way, because the defense is really, 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 really going, trying to, just in their cross examination, really cast aspersions and offer Hunter up as an alternate suspect. However, I would say that the messages between Megan and Hunter don't support that theory. We heard testimony yesterday where those private messages were read. And quite frankly, they show Megan once again. This is another example of Megan's lying liar face who tells lies, who lives on Liars Lane in the town of Liarsville. Like, at this point, I don't know how the local organizations go, but I would say that at this point, Letitia Stout and Megan Boswell are in a runoff for the mayor of Liarsville, really, because that's all they do is lie. And the thing is, and I hope that the prosecutor really, when they finish up their case, and they're given a chance, and it's time for closing statements or closing arguments, I would really like the prosecution to reiterate to the jury, although the closing arguments are not evidence, obviously, but they are a summation of the trial. And usually, when they do the closing arguments, they speak about evidence that, hey, if you don't believe me, go look at it for yourselves. It's all available. But I would really like to hear the prosecutor during their closing arguments reiterate the fact that, because the defense is really trying to say, oh, well, she was, being interrogated for hours on end, and it was just the same thing over and over, and they were focused on Megan, and they never stopped focusing on Megan. And that's not true. They listened to Megan, even though her stories did not seem plausible. They went and they vetted her stories. They followed all the leads that Megan Boswell gave them, which took away an incredible amount of time and an incredible amount of resources. It is my personal belief that even if Megan had come clean on February 18th, it would not have changed anything. It would not have saved Evelyn's life, which is awful. It's absolutely horrendous. Because I think that the reason there is no proof of life after December 6th is because, quite frankly, poor little Evelyn, sweet baby, innocent girl, was unalived around that time. That's why. So, you know, but they went all over Hell's Half Acre looking for this child. They went to North Carolina. They got the Army involved because she said that Evelyn was with Ethan in Texas. They searched barracks. They were where they did Tennessee, North Carolina, Texas, and Virginia. And so I think that it bears repeating in front of the jury that the defense saying, well, they were focused on Megan from jump, and their focus never changed. There is a such thing as confirmation bias, and there are times when, and I've seen them in cases where the investigator gets tunnel vision and they ignore any evidence to the contrary. They have their suspect, they have their theory of the case, the end, that's it. But to me, the way that the prosecution has been laying out the evidence shows that the investigators, that law enforcement went where the evidence led them. And at the end of the day, no matter what Megan Boswell was telling them, after it was checked out, after it was investigated, all the roads led right back to Megan. And I'm going to tell y'all right now, if she says in any of these dadgum interrogation videos or a text or anything that the investigators are barking up the wrong tree, and somebody says, "What tree?" and she says, "Me, I'm the tree," I'm quitting, because that's what Letitia said. And, you know, and I understand where the defense lawyer is coming from. Okay. He is doing his job. He took an oath as an attorney, and he is exploring every avenue. He's doing what he's supposed to be doing. I'm not angry at him for doing his job at all. Do I always agree with the tone in which he does his job? No. And do I also realize that attorneys are human beings? They're not miracle workers. They don't have some magic wand. The case is the case. And at the end of the day, Megan is guilty AF. And at the end of the day, he has the case he has, and he's got to do with it the best he can. And that's just what he's doing. I think it's going to be effective? Hell no. I don't think it's going to be effective. It's not, I mean, he hasn't moved me in one way at all. He hasn't moved me an inch. And I think that I enjoyed the testimony yesterday from the second medical examiner. I thought that she did an excellent job explaining things in a way to the jury and to us that are easy to understand. To me, it seems like, and I need to ask Melissa McCoy. I think it's McCoy, because at the end there, she said, "Go follow her on social media and let her know." And I waited, and I sent him a chat, and I said, "Do you think we could get her to talk on the channel?" And I waited for a while, and she didn't respond. And I thought maybe she had left chat because the live had ended. And then Allie sent me a screenshot because Allie was behind and she stayed to watch the rest of it, to catch up. And Melissa did send me a message. And Melissa, if you're here and listening, but not able to chat, just so you know, in response to your how can she contact you question, my email is on my about page. In fact, let me drop it for you guys in the oops. Come on, Jen, get it together. I know it's Wednesday. We might be tired, but it is. You've got to pay attention to what it is that you are doing. All right. Oh, Neat's got it. Thank you, Neat. So let me say good morning to you guys while we're waiting. Let me scroll up here because I've been live for a hot minute and I've been talking and you guys are talking. So now I'm going to scroll up to the beginning. Good morning, Queen Bella. There's Melissa. Good morning, Melissa. Oh, awesome. Melissa says, good morning, Jen Lou. We have a half day of school. I will be streaming with earbuds in. My husband will be talking with Dr. D, as we call her, about being a guest. She enjoys educating the public. Fantastic. Thank you so much. Good morning, boss lady. Good morning, preschool granny. Good morning, Tinkerbell wannabe. To answer your question, Tinkerbell wannabe, why do some of the chat messages disappear on my chat feed? First of all, I would check to make sure you're in the live chat. And if you leave the stream, okay, and come back in, you sometimes, most times, all the time, oftentimes, YouTube will not allow you to scroll back all the way back to the beginning of the stream with chat. So that might be it. Also, sometimes people delete their own comments. I very rarely, and the mods very rarely, delete comments over here. You got to really do something for us to delete it. That's just the way it is. Sherry, good morning. Mama Four, good morning. Gretchen, Claudia, good morning. Sarah, Bella, good morning. Margie, Michelle L, Becky P. Let's see. Neat Noodle, good morning. Boho Hobo, Wendy, good morning. Good morning, Desiree. Let's see. I want to say hi to all of you guys. Gretchen, Becky P. Ro, good morning. Good morning, Nightbot. Oh boy. All right. I think that I got pretty much. Good morning, Jenny. Struggle is real. Good morning. True crime T. Good morning. Cat's eye. Good morning. True Psych Ward. Good morning. OMG, True Psych Ward. Listen, not now, obviously, but when you have a moment, watch the last two witnesses from yesterday, particularly the last one. Good morning, Chick Tracy. Marjorie, good morning. Let me see. Chicken Lady, good morning. Griffey Bear. Hey, while I'm saying good morning to everybody and just kicking it with y'all, would you do me a favor and give me a thumbs up or a thumbs down? And Kayleen, good morning. Good morning, No Madness. Could you guys give me a thumbs up or a thumbs down, however you're feeling this morning? Teacup Kraken, good morning. Hey, Sherry, good. I think I already clicked on you. I remember saying good morning now. I think, hey, good morning, sweet Melissa. All right, I think I did it. I think I got to everybody. Good morning, good morning, good morning, good morning. So we're just waiting now for court to start. I'm personally waiting for them to bring Megan in because yesterday she apparently now I'm not going to say she found a brush, all right, but she did this is an old school trick where you braid your hair when it's wet. So I'm assuming she showered or she dunked her head in the sink in her bathroom. I'm hoping it was the toilet, but whatevs. It's neither here nor there. And, then she braided her hair, let it dry, and then took it out, so she looked like she had some kind of hairdo going on yesterday. That's the I will tell you that in my estimation, she and Letitia Stout and, Leilani Simon, quite frankly, shop in the, Motel 6 trial attire section of uh, where they give, I'm assuming it comes from the public defender's office there, where they bring outfits of the day for them, that's the section of the outfit of the day they're wearing because they look like they came from Motel 6. Although yesterday Megan gave us a change up and it was very Little House on the Prairie-esque. Like, her skirts are all the way down to her ankles, and they're too big, and then she had on, a button-up blouse that would have looked much better with the pant. I don't know what she's doing. I don't think she cares, quite honestly, which, um, I the country life of Chicken Lady, they do still sell sponge rollers, and you could get better curls doing, I think, and no heat using sponge rollers. They also have all kinds of, because I will sometimes, I need a break and I will scroll like YouTube shorts and I'll come across hair tutorials and they have all kinds of no heat, go to bed with them in your hair curlers uh now. So you don't have to braid your hair if you want. Because sometimes the braids, I don't know, maybe you're better at braiding than I am, but, like, they don't come out even for me. So, just a little suggestion. It looks like we're getting ready to start. I don't Where's your robe, Your Honor? It's always, like, a little weird to me when I see a judge at the bench, but they're not wearing their robe. It's almost like when you were a kid in school and you saw, like on field day, when your teacher would come to school dressed like in not teacher attire, like athletic attire, which is because, you see them every day and they're dressed like a teacher. They're wearing a business casual attire, but they come to school wearing like shorts and tennis shoes and they're ready for field day. I mean, it's not an inappropriate attire. It's just attire that you're not used to seeing them in and it sort of takes you aback. That's how it feels. Okay, so Stitch M says, "Morning, good morning. I'm so scared the defense is giving reasonable doubt to some with the autopsy questions. I don't want another Casey Anthony to walk. I don't know how this baby died, but Megan was the one." Okay, I don't believe that they've opened, and I understand your fear. I don't believe they've opened the door. A lot of so I A long time ago, and I've talked about this so many times. After Casey Anthony's Peacock series was on, Vinnie Politan, who covered Casey Anthony's trial and case, had on the judge who presided over her trial. And the judge said the reason that the jurors found Casey Anthony not guilty is because the coroner or the medical examiner was unable to say specifically what her cause of death was. And the jury didn't understand that was not a necessary element, that they didn't have to know exactly what caused her death, that it was homicide, because there was no special jury instruction to that. It wasn't spelled out in the jury instructions. So that's what he said. And I believe the judge, because why would the judge lie? And I will say that when the jury, some of the jury, the members of the jury have spoken out, they have said they didn't know that the state didn't prove Kaylee Anthony's cause of death. Okay. But they weren't required to, and there wasn't a special instruction. I think many prosecutors from all over the United States have learned from that case. And so I think that this time it'll be different.
And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in and had to send it back out.
Yes, Judge. The state intends to introduce a certified copy of
What?
from the Circuit Court in Bristol, Virginia, which ordered.
Hold on a minute. Let's hear what's going on.
Yesterday, the state indicated they may have another witness or at least exhibits. And then at the sidebar, I was told that there might be an objection to whatever the exhibit is.
Yes.
So I thought we'd take that up before I brought the jury in and had to send it back out.
Yes, Judge. The state intends to introduce a certified copy of the order from the Circuit Court in Bristol, Virginia, which ordered Hunter Wood involuntarily committed to the mental hospital over there in Marion. There's a copy of the appearance by the attorney over there, the request for evaluation and report to be done, and then there's a letter dated January 10th, 2025, which is from the Southwestern Virginia Mental Health Institute updating the court as to Mr. Wood's status. And like I said, it is I believe, a self-authenticating document. There's a certificate of official record that is attached, signed by the judge of the Circuit Court in Bristol, Virginia.
We have no objection, Judge.
Okay. So what I intend to do, and then after that, do you think you'll have any other proof?
No, Your Honor.
So what I'll do is I'll bring the jury in, admit that as the next numbered exhibit, then you can rest in front of the jury.
All right, you guys, the state is fixing to rest. Okay. Now, this is day 7. They said the trial would go 3 weeks. I want to ask you guys in the chat currently, right now, okay, Stephan Sterns, his pretrial hearing. Hold on. All right, so the state is, I'm sorry, you guys, the state is fixing to rest. And they're going to introduce evidence that Hunter Wood was involuntarily committed to the psychiatric hospital. However, currently, right now, Stephan Sterns is his pretrial hearing is going on and it's being streamed live. Do you guys want me to switch over to that, watch that live, and then we'll be a little bit behind, obviously, and then we can watch Megan Boswell? What do you guys think? Let me know in the chat. Sorry, I was choking. All right, I see Mama 4 saying yes. Hang on. Let me see who else is saying yes. I see one answer to yes. I see 2 yeses. There's such a delay between all right. Yes. All right. So we're going to switch it out. We're switching. All right.
That's like one nice thing about medical school. My cousin says, you gotta get the heart. I think I did Florida law.
Hang on a minute.
Just as a reminder, make sure your cell phones are off or on silent. No texting or talking inside the courtroom.
All right, good morning again. Welcome to pretrial. At pretrial, we're going to be discussing your cases with the attorneys. I'm going to be inquiring of the attorneys what the status of the case is, whether there's reasonable cause to grant more time to prepare for the case, whether the case is in a position to resolve, or whether the case should be set for trial. You should have all met with your attorneys prior to this date. You should have received an offer of resolution for your consideration. I'm going to take a couple of cases out of order that require the assistance of our live court reporter. State of Florida versus Stephan Sterns, 2024, CF 632.
Danielle Canal for the state.
Oh, we just don't know what happened with the
Court received the waiver of Mr. Sterns' disappearance pursuant to our administrative order. That waiver is accepted. The court has also received what's purported to be an unopposed motion to continue. I noticed when reviewing the docket, there's been 3 motions to suppress evidence filed on February 6th. Looks like those motions deal with a search and seizure of a cell phone and the material contained therein. Those been coordinated with my office since that we're here.
Not yet, Judge.
That have been continued twice before in April and July. Office of Public Defender's been on the case for almost a year. When do you anticipate resolving these motions?
There's one other motion that I have to file, and I'll be asking the court to hear before the motion to suppress. I intend to get that motion filed by the beginning of the week, and at the end of this week, but I'll be reaching out to Ms. Hackman in regards
What's the substance of it?
to it regarding clothing order.
Ms. Fennell, the motion to continue was reported to be unopposed. Do you agree these matters need to be resolved prior to trial?
For the integrity of the case, yes, Judge. The evidence viewing that was scheduled in this case ended up having to be canceled because both Ms. Smith and I ended up in trial and the other attorneys were not available either. So that is scheduled in March, and I don't believe that we would be able to proceed to trial until the defense has had an opportunity to review that evidence and these motions are resolved.
Right, the matter is going to be continued without opposition from the state. Our next trial is going to be on April 22nd with a trial period that begins May 5th and runs through May 21st. My apologies, April 23rd will be the pre-trial date with a trial period that begins May 5th through May 21st. Anticipate that the motions and hearings will be scheduled in advance, and heard and resolved in advance of the April 23rd pre-trial date. Anything further, Ms. Smith?
But I have a proposed order for it.
Thank you, Ms. Fennell.
Nothing further.
Thank you. That'll conclude our pre-trial on Stephan Sterns, 2024 CF 632.
The support the proposed order you have your access to the motion.
State of Florida versus Larry Rhodes.
All right, that's it, y'all.
We have 1914.
And we just don't know what happened with the road.
So Stephan Sterns will go to trial May the 5th, which, as you guys know, or may not know, but I'm going to tell you, is a particularly significant day for me for 2 reasons. One, May the 5th is the day that Christopher Byers, Michael Moore, and Stephen Branch went missing and were found the next day. All 3 of them 8-year-olds murdered in West Memphis, Arkansas back in 1993. It's also Cinco de Mayo. Viva la raza! So it's a sad day. All right, so now we're over on Megan Boswell's, and the jury, the state intends to rest, which, wow. Let me make this clear. They intend to rest their case in chief. That they have a rebuttal case if the defense decides to put on a case. All right, here we go.
And then I'll have to send them back out so we can take up some matters out of the presence. All right, we can bring jury in if we're ready.
I'm proud of us. We multitasked. I got the title changed. We're doing it. Aw,
Everyone
chicken
stand,
lady. Just going to mute a little bit while the jury's brought in. I wish you lived closer, chicken lady, because let me just say this. I have been wanting to get a kitten for myself, obviously, but also for Alice and Mac, because I think they've reached the point in their relationship and in their lives where they need a little responsibility. And they're not like they're old enough, but not too old. And I would love to get a little kitty for them, but I only want to rescue. See, that's my conundrum because kittens are always adopted. So I don't know.
We introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. If we would offer that as the next exhibit in this case.
Number 261.
261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit 261. All right, call you next.
Judge, stay with rest.
All right, ladies and gentlemen, I know you've only been out here for 2.5 minutes, but I'm going to send you with the officer. for a few minutes.
Everyone stand, please.
I'm going to tell y'all that what he just introduced into evidence is very, very important. Okay, he was involuntarily hospitalized. This takes away from
You may be seated. Thank you.
our curiosity and the jury's curiosity and the defense's
Mr. Scott.
intimation that,
Judge, pursuant
hold on a minute, it takes away any of the aspersions. I mean, we were all curious about it. We all were like, wait a minute, this timing seems sus, okay? But at the end of the day, this young man didn't want to go to the mental health hospital. He was made to go to the mental health hospital. This was not something done by his parents or his family in an effort to keep him from testifying. That was my point. Here we go. Let's hear from Mr. Scott.
Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts.
Told y'all, this is the next
Just briefly,
thing.
I'll go through them. As it relates to the first 3 homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was asphyxia, she later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count 1 and premeditation, there is no evidence whatsoever in this case of premeditation. So those are the 3 murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect its health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law. So those are my arguments to those counts. As it relates to tampering with evidence, I'll leave that to the court's good discretion. False report, obviously, there is, as it relates to those, there is a double jeopardy issue that the court will have to address if the jury returns multiple verdicts on those. But I will leave those for now, but I do move for a judgment of acquittal without further argument. And the same with abuse of a corpse and failure to report a death. I'll move the court for a judgment of acquittal.
Jim?
I'll be brief, Judge. Of course, the court reviews this motion in viewing the evidence in the light most favorable to the state. As far as Mr. Scott's argument regarding premeditation, I think the proof's been pretty clear in this case. The child's found upside down, stuffed into a trash can with its head wrapped in a blanket, and then on top of that, there's a substantial amount of aluminum foil. I think that clearly shows an intent to murder. So we would argue that the element of premeditation is at least shown through the physical evidence in this case. As far as the remaining counts, it's showing the cause of death. Both medical examiners, their opinions as they came in yesterday were that this was a homicide and that Evelyn Boswell died from asphyxiation. Mr. Scott certainly challenged and threw some other possibilities out there, but at the end of the day, that was their opinion as to the cause and manner of death. So I believe that the proof has been sufficient at this point to show how the child died and to let the jury make decisions on all the remaining counts.
All right. Of course, as Mr. Scott and the general has stated, in viewing the evidence in light of the Rule 29 motion for judgment of acquittal, the court's required to view the evidence in the light most positive to the state. And looking at these charges and the proof through that lens, with regard to count 1, the premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, you couple that with the voluminous amount of evidence where the defendant was given different stories as to where the child was, as to how the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that date, it was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But courts of the opinion the state, when looking at that proof in the light most favorable to the state, that they have put forth evidence that the jury can consider. So with regard to count one, I'm going to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taken in the light most favorable to the state, the fact that that child was wrapped and placed in the garbage can, I think the jury can look at that. And I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy, dirty, toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking the light most favorable to the state, that those two counts would survive the Rule 29 motion, and I'm going to deny the motion with regard to those two counts as well. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in the light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Moman versus State questioning, and I'm going to hand this down and let you do that.
Judge, for the purposes of the record, would you like her to come to the...
No, just put the microphone back up on the table for that. We just need to make sure she's recorded.
All right, so for those of you guys who are just coming in, the state has rested. So the defense moved for a verdict of acquittal from the judge, stating that the state had not proved their case in the following ways. And they listed all of those ways. They basically said that they failed to prove that it was that Evelyn Boswell, they failed to prove her cause of death. Therefore, they failed to find her manner of death as homicide. It could have been an accident, basically, is what he said. The judge just summarily dismissed them all. That's what we were just listening to. Now we have just learned that Megan Boswell will not be testifying, which, quite frankly, is probably a good idea. She doesn't seem like, I mean, look, she's lied enough, and there's no way that she would at all be a good witness for herself, and the state would likely eviscerate her. So verbally, not physically, but here we go on cross.
Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation of you and explaining to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes.
Okay. And part of that, I've talked to you about you have the right to testify. Is that right?
Yes.
And if the jury can't hold it against you if you don't testify. Do you understand that?
Yes.
Do you understand you have a right not to testify?
Yes.
Okay. And if you decided you wanted to testify,
Excuse me, Mr. Scott. Let me tell you what I will be holding against Megan. The fact that in all this time we've been sitting here, we're on day 7 of testimony, and she hasn't been able to find a dadgum brush. If you can't brush your hair, ma'am, put your hair up. You look a mess.
I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
Yes.
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as to whether or not you want to testify?
Yes, I have.
Do you want to testify?
No.
I think I covered it, Judge. Approach.
Yeah.
Oh my goodness. The jury isn't in here. I don't know why we need to approach. What's the deal? Is there some chicky nuggies up there? Listen, I'd approach for some chicky nuggies.
No. I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge
What?
and give the parties time. Because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we will bring them back and I will read the charge to the jury up until almost the end. And then I will have you argue your case, and then I will finalize it and send it out to the jury. That's the
Yes, sir.
process going forward. And during this extended break, it will give you all time to go through your notes, go through the exhibits, organize your thoughts for closing argument. Okay? So we need to bring the jury.
Okay, so there you have it, you guys. The defense is not going to put on a case. Listen, they're not required to.
Give the curative instruction about
Yes, sir. I was going to ask about that, but I forgot.
I did too.
They're not. The defense is not going to put on a case, which means there's not going to be a rebuttal case put on by the state. which means no Angela Boswell testifying. They all feel like they
Everyone
did
stand, please.
their job and they're good. I don't know why they thought this case was going to go 3 weeks, but I mean, even let's be on. Let's talk about this. Like, even with the first day, there only being one witness.
You may be seated. Thank you.
I don't know why they told these jurors they were going to be there for 3 weeks.
Okay, ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, it is.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that? Yes, sir.
I
I'm going to
do.
instruct you that that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider it? If you can, raise your right hand. Let the record reflect that all the jurors have raised their right hand. Now, Mr. Scott, the state has rested. Will the defense have proof?
Defendant rests.
All right. Ladies and gentlemen, where we are now is the proof is closed, but it is not time for you to begin deliberating or talking about the case. We're going to have to take an extended break because I've got to prepare and finalize the jury charge. And then I'm going to make a notebook for each of you with the charge in it so you can follow along, and you'll have that for your reference while you deliberate. Okay? This will also, and what'll happen is it'll probably take 45 minutes to an hour. I'll get all the notebooks made.
To answer your question, Gina, if they stream the jury instructions, we will watch the jury instructions. These are very, very important, in my opinion anyway, and I like to watch the jury instructions. It's kind of dry, obviously, but I like to watch them. So if they stream them, we'll watch them.
We'll give the lawyers time to organize their thoughts for closing. When we come back, I will hand out the notebooks and I will read you the charge, which will be painful, and I apologize for that, but that's the way it is. And then we'll go straight into argument. Okay? So I apologize for the length of the break, but just bear with me. It's necessary. Okay? You'll go with the officer. Everyone stand, please.
Yeah, it sounds like we're going to get closing and we're going to get,
You may be seated, thank you.
they'll be for deliberation, so we'll be on verdict watch.
We'll probably take 45 minutes to get these books done. Court stands in recess.
Okay, so the court stands in recess. I'm guessing that they have already discussed these jury instructions. And so now what's left to do is put them all together in binders or little notebooks for the jury. And then the judge is going to read them out. So, okay, this is what we're going to do for those 45 minutes, because never let it be said that Bindi Lou just sits on her laurels and does not do the work. This is what we're going to do. So I'm going to rewind back. So 45 minutes, Sweet Melissa. Sweet Melissa, I don't know if you heard me, babe, but you can get a hold of me by my email. Let me drop that once more in the chat for you because I would love to speak to that doctor. And sounds like she's been released from her subpoena, which means that she can speak. All right. Oh, thank you, Gina. I appreciate that so much. So this is what we're going to do. I'm going to rewind it back to the defense's motion for judgment of acquittal. Okay. And we're going to listen to it. And then we're going to go back and listen to the testimony that he's referencing. Okay. Because obviously, this is something that needs to be talked about too. When the defense moves for a directed verdict, um, motion for acquittal, they're all kind of the same thing, right? Um, the the arguments that they make with respect to the evidence is no court TV, no, no, we're not listening to that hold music. No, thank you. If you're going to put on hold music, court TV, make it a banger. The evidence that they cite, the judge, when listening to the argument from both the defense and then the state, must view the evidence in light most favorable to the state. And I think the reason why is because, yes, the defendant has the presumption of innocence. Okay. But there were many, many things that occurred in the justice system before they even got to the trial portion. Okay. And those take place in pretrial hearings. There was a grand jury indictment. So there are a lot of checks and balances and steps along the way. And so that's why I believe the evidence, when they make that motion for a verdict of acquittal, the evidence is viewed in the light most favorable to the state. All right, so let's rewind a scotch. And by the way, we were behind anyway. So let me turn this up.
Stephen, thank you.
Judge, pursuant to Rule 29 of the Rules of Criminal Procedure, I move the court for a judgment of acquittal as to all counts. Just briefly, I'll go through them. As it relates to the first three homicide counts, the state has failed to prove the cause of death, which is required to be proven beyond a reasonable doubt. I understand the burden here is that the state has to prove it in a light most favorable to the state. The court has to look at it from that standpoint. Even when looking at that, Dr. Schmidt testified to various, although she stated that she believed it was a fixie issue, later under cross-examination admitted it could have been a SIDS death. She admitted that it could have been a heart issue, or it could have been a laryngeal spasm that caused the death. She really couldn't specify the manner of death. When it came to Dr. Malushnik, she testified that she felt like it was asphyxia caused by being placed in the trash can, but ultimately she did answer that she could not conclusively say that the baby was alive or dead before being placed in the trash can. As it relates to count one and premeditation, there is no evidence whatsoever in this case of premeditation. So those are the three murder counts. Aggravated child neglect, the state hasn't produced any evidence that the child was neglected in such a way to adversely affect its health and welfare. Similarly, of abuse, there's absolutely no proof in the record of child abuse. In fact, there is ample proof to the contrary. Both medical examiners testified there was no broken bones. There's no trauma there. There's testimony, I think, from 6 lay witnesses talking about Megan was a good mother, a loving mother. They never saw any signs of abuse. The pediatrician testified that she never saw any signs of abuse, or she would have reported it under her duty under the law.
All right, we're going to stop right there. Okay. And we're going to look up oh, that's a good idea, Neat Noodle. Okay, so we're going to stop there, but before we go to the next part that I want to play for you guys, I'm going to rewind so you guys can hear the situation with Hunter.
Do any of the jurors have anything to report with regard to those admonitions? If you do, raise your hand. Let the record reflect that none of the jurors raised their hand. All right, General.
Judge, at this time, the state would move to introduce what we believe is a self-authenticating document, which is an order from the Circuit Court in the city of Bristol, Virginia, which orders a mental health evaluation on Preston Hunter Wood. It also contains a letter from Southwestern Virginia Mental Health Institute, which is dated January 10th, 2025, which talks about the fact that he has been involuntarily hospitalized at that facility. If we would offer that as the next exhibit in this case.
Number 261.
261, I believe.
261, any objection?
No, sir.
All right, that'll be exhibit.
All right, so there you have it. If you missed it this morning, that was the last piece of evidence that the state introduced, which is documentation that, first of all, Hunter Wood, Megan Boswell's situationship at the time of the crime, was ordered for a mental health evaluation, and he is currently involuntarily hospitalized. Okay, so any of the questions that we may have had, and they're normal to have questions. It's the way that the testimony came out. It did seem like convenient timing. So there's that. Now, the first thing we're going to listen to back is, because these are the most important, okay? The jury can find that Megan Boswell premeditatively murdered her child, okay? And I've talked about this so many times. Typically, we think of premeditating as its definition in the dictionary, but it means something different when it comes to the legal definition of premeditation. There isn't a specific time of the legal definition of premeditation. It can be 1 second, it can be 1 minute, it can be 1 hour, 1 day, 1 week, 1 month, 1 year. All of those things, okay? It has to do with when the person did what they did. Okay, so in this case, asphyxiation. Okay. If it is that Megan Boswell smothered Evelyn, if that's the way she was asphyxiated, okay, and by that I mean Megan placing her hand or a pillow or some other object over Evelyn's face that would obstruct her breathing. The moment she used whatever it was that she used, her hand, a pillow, something else, when she picked that up or used her own hands and obstructed the child's ability to breathe via her mouth or her nose, because that's the only way us humans breathe, the action of putting something over the child's nose and mouth is premeditation, because she knew when she obstructed that child's ability to breathe that her actions would likely result in the child's death. Okay, that's what premeditation is. Now they can find or they can find felony murder. Let me see what the legal definition for felony murder is. in Tennessee. Okay. Apparently, I don't know how to spell Tennessee. According to the AI overview, it goes like this. Tennessee's felony murder rule allows prosecutors to charge someone with first-degree murder if they participated in a felony that resulted in death. This is true even if they didn't kill the victim or were not present when the killing occurred. The felony murder rule is an exception to the normal rules of homicide. The prosecution only needs to show that the defendant participated in a felony that resulted in a death. The defendant doesn't need to have intended to kill the victim or acted with reckless indifference. The felony murder rule applies to crimes that are considered inherently dangerous. What felonies are covered? Arson, burglary, kidnapping, SA, robbery, theft, aggravated child abuse or neglect, and aircraft piracy. So that's why they've charged her the way that they have, okay? Because they can find that she didn't necessarily intend to kill Evelyn, but that she is guilty of aggravated child abuse and or neglect, because those are charges that she's charged with those. So they can say, okay, she's guilty of aggravated child abuse. She's guilty of aggravated child neglect. And therefore, we find that she is also guilty of felony murder, because whatever it was that she did, she committed that felony of abuse and or neglect, and that even if she didn't intend for Megan or for Evelyn to die, she did, and she has to be held accountable for that. So that is why that charge exists. Becky asks, we're going to re-listen to the medical examiner's testimony, both of them, okay? So Becky P says, didn't part of her positioning in the trash contribute to the asphyxiation? Okay. Part of the problem, there are two different medical examiners testified. Okay, it's not a problem. Let me just strike that. Let the record strike that, Your Honor. All right. Here's the deal. Two medical examiners testified. One medical examiner said, who is the person who performed the actual physical autopsy. Okay. And that is a clarifying point. That is not an opinion, and it means nothing, only that she's the one that performed the physical autopsy, who ruled that that Evelyn was asphyxiated and then wrapped and placed in the garbage can, in the trash can. The second medical examiner, who I'm going to let you, when we replay it, she's going to go through all of her credentials and stuff like that, reviewed all of the material, including the autopsy report and all of the investigative materials. And she concluded that it is likely and that Evelyn was placed in that trash can alive. And here's why she said that. It is what we have to take into consideration here is the condition of Evelyn's little body. She was very, very decomposed. And there are things during an autopsy that decomposition, and to the level that Evelyn was decomposing. I hate saying that because it's so hard, but it's what it is. That decomp can obscure during an autopsy. One of those things is seeing actual contusions or bruising, okay, on the physical body with just an external, just visible to the eye, because there's pooling, there, the lividity, then the decomp changes the color of the skin, all of those things, okay? So it would have been very, very difficult. Now, one of the things that they likely might have been able to tell at autopsy is the situation where there was an accusation that Evelyn's arm was broken. Those are when a bone is broken, you can see it on X-ray, and then when it heals, you can see that where it healed on X-ray. So if that occurred, um, they would have been able to see it upon X-ray. One of the other things that they can see, which if you think back to Quentin Simon's autopsy, is if there are defects in the skull. Okay, those are visible, and they can tell based on the appearance of the defect, and also they study it under a microscope. There's X-rays, all of those things. They can tell that whether or not the defect in the skull occurred at or near the time of death, which is what caused the death, or if it occurred after death. That is why they were able to rule out the defect in Quentin Simon's skull being the result of being placed in the dumpster, then the dumpster being emptied into the trash truck doing the compacting, and then subsequently being placed in the dump, and all of those things. It occurred at or near the time of death, which is why that's how they ruled that it didn't occur as a result of things that occurred after death. Okay. Now, what the second medical examiner testified to is that the manner in which the blanket was wrapped and the foil was wrapped would be unnecessary if the child were dead. This wasn't a child that was just like wrapped in an effort to obscure her body being visible in the trash bag itself. Okay. This wasn't that. It was tightly wrapped, the blanket and the foil being so tightly wrapped that you could see the impressions left from Evelyn's little face. And so the second medical examiner said that's an incredibly intentional act to perform on an already deceased child. So she agreed with the first medical examiner in that it was asphyxia, but that the asphyxia likely occurred as a combination of multiple things. One, the blanket and the foil and the trash bag itself. Two, the position in which she was placed in that trash can, upside down, which would cause, just in and of itself, if none of the other things occurred, no foil and no blanket, or being placed upside down in that trash bag in the trash can, would have resulted in positional asphyxiation, because human beings that are kept upside down for long periods of time, you can't breathe that way. And also the way that her little head was situated. Okay. So that is what that specific medical examiner testified to. And again, because of the length of time that occurred between Evelyn's death and when her little body was located, thanks to you, Megan Boswell, it was very there are certain things, that they just can't tell. But I personally, we all sat here and we have been talking about since before this trial even started, the foil aspect. Why was that foil placed there? Why was the foil there at all? And so when she testified yesterday, that is an incredibly reasonable explanation as for why. Why was she put in the trash bag and then in the trash can upside down in the first place? Was it because she was somewhat alive and putting her in the trash can right side up, she could walk? Is that why? Those are, and I do think that even though the cross-examination by of the second medical examiner was a little contentious, I don't think the defense scored any points. So what I'm going to do right now is we're having all of that in mind, okay? And I want you guys to take everything else out of your mind, right? Let's just listen to this medical examiner's testimony, complete blank slate, right? Because this is how the jury would be listening to it, okay? And let's listen to it and see. I've already skipped ahead to skip the part from the first medical examiner's testimony about her education. We get it. She's extremely smart, well-educated, and more than qualified to be an expert witness. And start from where she actually talks about what she found and all of those things, okay? And we're just going to listen to it like that, and then we're going to discuss it. All right, here we go. Let me rewind just a scotch. All right.
Describe the process of this particular autopsy for the jury.
We re-photographed the body. We collected evidence from the body, and we removed the clothing, and I performed the autopsy, starting with an external examination, then an internal examination.
Okay. Was it more difficult due to the state of Evelyn's remains?
I don't understand
Okay,
the
let me
question.
ask it in a different way. Does decomposition of a body impact your ability to perform certain things during an autopsy?
It can,
Okay.
yes.
Can you, for example, does the level of decomposition keep you from being able to identify mechanisms of death or possible mechanisms of death?
It can, yes.
Can you describe how?
Sometimes with decomposition, the skin will change colors, and it can obscure bruises or contusions. Sometimes we might not be able to draw the sufficient toxicology specimens that we want to.
Okay. And did any of that happen in this case? Were you able to see any potential soft tissue injuries to Evelyn's body?
I did not identify any soft tissue injuries.
Okay. Did decomposition play a role in that at all?
It's probable, yes.
Okay. I know you stated in your report that there were leaves in Evelyn's hair. Is that correct?
Yes,
Okay. And you were also at the scene. Did you observe leaves at the scene that night?
yes, there were numerous leaves inside the shed playhouse.
Okay. Okay. So I'm assuming when you conduct an autopsy, it's not just the body itself that's helping you make your determination. Is that a fair statement?
That's correct.
Okay. what other materials do you as a doctor use in order to make a determination when you're conducting an autopsy and trying to determine a cause and manner of death?
Our investigators' investigation or summary, law enforcement's investigation. I can use medical records, sometimes histology. That's where I take the tissue and I look at it under a microscope.
Okay. Okay. And after you conducted the autopsy of Evelyn, are those results essentially generated into a report?
Yes.
Okay. Is that report kept in the normal course of business?
Yes.
And have you reviewed your autopsy report for accuracy and completeness?
Yes.
I'm going to pass you documents. I'm going to give you a second to look and see if you recognize that. Oh, okay. Are you able to identify that document?
Yes.
Okay. Can you tell us what it is?
It's the autopsy report I prepared on Evelyn.
Okay. And is that a complete and accurate copy?
Yes.
Okay. Your Honor, this time we would ask that be made exhibit number 260.
No objection. Full exhibit 260.
Dr. Schmidt, did you form an opinion as to the cause and manner of death of Evelyn Boswell?
Yes.
Okay. What is your opinion?
The cause of death, homicidal violence.
Okay. And can you explain that for the jury? What did you base that finding on?
I based it on the autopsy findings, the investigative summary, the investigators that went to the scene, and law enforcement investigation.
Okay. Hypothetically, if Evelyn was alive when she was placed in the trash can, is positional asphyxiation likely?
Yes.
Okay. Can you tell the jury what positional asphyxiation is?
It's your body's in a position that compromises your breathing.
Okay. And were you aware was how Evelyn's body was placed into the trash can? Do you recall?
Yes.
Okay. And when you say positional, are you referencing the fact that she was upside down?
Yes. The body was in the trash can, upside down.
Okay. I'm going to show you what's been pre-marked as exhibit number 34. Pre-admitted as exhibit number 34. Okay. Okay. So hypothetically, if a blanket is pulled up over the face of a child who's then placed into a trash can upside down, could the blanket itself cause some type of asphyxiation?
Yes.
Okay. What about the trash bag that Evelyn's body was in? Could the trash bag itself cause some type of asphyxiation?
Yes, if it covered the airways, the nose and the mouth.
Okay. How many autopsies have you conducted over the course of your career, just approximately?
3,600 approximately.
Approximately how many of those were on children?
Close to 100, between 80 and 100.
Okay. Have you conducted autopsies on children that have resulted from, that you determined to result from natural causes?
Yes.
Okay. Have you conducted autopsies on children that have resulted in or been caused by something accidental?
Yes.
Okay. So if I gave you a hypothetical that Evelyn Boswell was sleeping in a bed with an adult or two adults and a rollover sleeping episode occurred, is that something that you would consider as being a possibility for her death in this case? Do you want me to rephrase the question?
Yes, please.
Okay. Is a rollover incident possible, a co-sleeping rollover incident possible, explanation for Evelyn Boswell's death?
My opinion, no.
Okay. And can you explain why that's not a possibility?
Evelyn is an older child, and typically we see the overlay in younger children. It's certainly possible, but with the investigation of the scene and law enforcement investigation and the way she was found in a trash can, I don't have the opinion that it was a co-sleeping, bed sharing, or overlay.
Okay. Is there any scenario that I could give you that would change your opinion about the cause and manner of the death of Evelyn Boswell?
I don't know if I could answer that.
Okay.
Okay, so if I yell, it's accidental because I have multiple tabs open, one of them being the tab to the current live stream of the trial, which we are listening to hold music for. So it's in my ear as well as this doctor's testimony. Okay, so one of the things that I want to point out here is I'm trying to think of how to say this. It is an attorney's job during trial to elicit testimony from a witness, okay? The witness is only allowed to answer the questions that are posed to them. I am not a big, huge fan of the way that Prosecutor Massengill asked these questions of the medical examiner, of the forensic pathologist. I think had the questions been asked in a different way, um, I think the answers would have been more clear for the jury. I think that this particular medical examiner's personality is such that, and the way that she processes questions and then answers them, she deals in facts. And it, it she can come across. Hold on just 1 second, please. Let me let Mac in. Please hold. I apologize. Sorry about that. Okay. Um, so I think that when she asks this last question, I think the reason that the medical examiner is having a difficult time answering that question is because of the way that it was asked. It's too open ended. Um, and she doesn't feel comfortable asking that because to answer that, what she asked was, is there any scenario that I could give you that would change your opinion about the cause and the manner of Evelyn's death? That's, I mean, it's way too open ended because the answer to that question would actually be yes. Because when you listen to the testimony, when she made her ruling and her findings, so the autopsy is one element of all of the information that this forensic pathologist used in determining the cause and the manner of Evelyn Boswell's death. Okay. So, what, so if the circumstances, right, not the autopsy, not the autopsy, that part, the findings of an autopsy are the findings of an autopsy, but that she didn't just use her findings from the autopsy. She used the investigation and medical records. So if the circumstances in the investigation were to change, that might have then the outcome might also change. That's why she can't answer that. Okay. I wish that she would have asked that. I wish she wouldn't have asked that question at all. ATS News, are you perhaps in the chat? If you are, could you check Messenger, por favor? Okay. Let's play the rest of this and see what we can see.
Do you, hold on one second.
No, hold on one second.
Boswell died from natural causes. The autopsy. Let me ask it a different way. Anything about the autopsy, as well as the other things that you had said that you used to come to your conclusion, that led you to believe that Evelyn Boswell died from natural causes?
No.
Okay. Same question. Anything based upon the history that you were given from law enforcement, the scene itself, plus your autopsy of Evelyn's body, that led you to believe that Evelyn died from something accidental?
No.
Okay. Please answer any questions that the defense has for you.
All right, before we get into his cross-examination, I want you to know that the jury is supposed to be back any minute now. The minute that court resumes, I will obviously stop this screen and share from there. Just in case you guys are wondering, I will not allow me or you to miss anything that goes on in the courtroom today. I promise. Okay?
I approach the court reporter, Judge. Scott, how are you?
Good afternoon. I'm good. Thank you.
I think we've met once before. It's good to see you again. I do have some questions about your report and your conclusions. And I guess I'd like to know what you relied on in forming your report. You talked about the investigations of law enforcement. Obviously, you did an autopsy on the body. Did you go through Evelyn's medical records, the OB records from when her mom was pregnant with her, and her pediatrician records?
I routinely go through the medical records. I remember going through the pediatric records, but I don't remember the OB/GYN, but I might have went through them.
Do you think it would have been helpful to have done that?
Yes, I always review the medical records on
Okay.
children.
And Ms. Massengill finished up by asking you if anything could be said to convince you this was by natural causes somehow. And it's your opinion it could not be, I assume.
Based on my autopsy examination, no.
Let's talk about your autopsy examination. Are there any medical findings of a cause of death, or is it simply the way the body was placed?
There are no natural medical disease processes to support her death.
Yet there are no medical bases for her death based on your autopsy, are there? For instance, give me a hypothetical. If the child were found laying on a table as opposed to in a trash can, would anything have changed about the findings you found in your autopsy report about her medical conditions?
No.
So,
Okay, let me translate here. This is also a very poorly worded question, and here's why. Because I understand what he's trying to elicit out of the medical examiner. That is the role that where the victim was found, where Evelyn was found, which was upside down in a trash bag inside of a trash can. If she were instead found laying on a table, would that change the findings? Well, of course it wouldn't, because at the end of the day, the child, Evelyn, has been found with a blanket wrapped tightly around her, including her face. And then there is a layer of foil that was wrapped tightly around that as well. So, no, it's a very poorly worded question. And this is why, you guys, I don't think that the defense, no matter how he tried, was able to take away from the direct examination and introduce reasonable doubt.
you mentioned in your report that there is a possibility that the decedent was alive when placed in a trash can cannot be excluded, correct?
Yes,
You cannot conclude that either.
that's correct.
You don't know one way or the other.
That's correct.
Okay. So you talked about natural causes, and there's no sign of disease or anything of natural causes, correct?
There is signs of disease processes, yes.
Okay, so Neat says they probably would have changed actually. If she was found on a table, her body would have not been in an S curve. That's true. However, if she had been found on a table with the blanket and the foil wrapped around her face in such a way that it blocked her nose and her mouth, her ability to breathe, it wouldn't have been an accident then either. Am I making sense? It's the tightly wrapped blanket and foil that the only thing that she wouldn't have been able to find is potentially positional asphyxiation, because the positional asphyxiation comes literally from the position that her body was found in, upside down in the trash can. But if she had been laid on a table and the blanket and the foil wrapped so tightly that it prevented her from breathing, right? It blocked her airways, her nose and her mouth, then they would have ruled out positional asphyxiation, but not asphyxiation entirely. Does that make sense? Am I saying that right? Sometimes it comes out of my mouth different than it is in my brain. The jury is still not back yet, you guys. I have this hold music in my ear.
In this autopsy?
Yes.
Okay, what are they?
There is a patent foraminal valve, which is just the septum between the atria and the heart, did not close properly.
Now, this testimony is particularly important because even though Evelyn's little body was in the advanced stages of decomposition, not everything that didn't obscure all manner of testing. And for example, there were some disease processes that were revealed during autopsy that advanced decomposition didn't obscure, which is this heart murmur that she had. Now this neat noodle, 11 billion, 1,050, 1,100%. Absolutely. Neat says, y'all realize that if the defense had found a medical examiner who was willing to testify to a different conclusion than the state's MEs, they would have called them to testify. Abso-freaking-lutely. Absolutely, totally, and completely. And don't think that they didn't try. They tried. They had to have tried. That was part of their defense. They needed to get somebody that would have been part of just preparing the case, right? They needed to get an independent forensic pathologist. They're back. Hold music stopped. They needed to get an independent pathologist, forensic pathologist, to conclude that this was a potential rollover scenario. And at the end of the day, they couldn't. And I suspect the reason that they couldn't had to do with the foil and the blanket. And I will say that in my estimation, the first medical examiner did a great job testifying, but the second medical examiner did a better job because I need to find out from Melissa
I'm going to ask
McCoy.
this one last time. Have y'all?
I don't want us to miss any of this, but I want to finish my point because it will be stuck in my head and then I won't be able to move on from it. I think that the second medical examiner testified that she also did teaching, and that I think is the difference between the first medical examiner's way of testifying and the second. That is all. That's all I wanted to say. I'm going to rewind it a couple of seconds so we can hear this in its entirety. Ready? Here we go.
I'm going to ask this one last time. Have y'all reviewed the final charge or the charge in its final form?
I have, Judge.
I have to.
And on behalf of the state, General, do you accept the charge as written?
Yes, Judge.
Mr. Scott, on behalf of the defendant, do you accept the charge as written?
Yes, sir.
All right. What I'm going to do, it's 81 pages long. I'm going to bring them in, give them the charge. I'll probably, of course, I have to read all the judgment forms. If you look at it on page 49, I'm going to read down to, I'm going to stop where it says when you retire to the jury room. I'm going to wait and give them that part after y'all argue.
So, Michelle, what they're doing right now is they're about
I
to
would
bring
ask-
the jury
ask if
in.
the state's ready, but I think General Harper just left.
What they're going to do now is they're going to bring the jury in. The judge is going to read the charges, And the jury instructions up until page, I think he said 49, he will stop at that point, and the state and the defense will have their opportunity for closing arguments. That's what's going on currently.
He's coming right back. He left his copy of the jury instructions on his desk. He's just grabbing them. The state is otherwise ready.
And I won't say it, I'm sure I won't think to say it, but the presentment is required to go back with the jury charge, and it's in the back of the book.
Your Honor, count 18, was that redacted out? Just making sure?
Yep.
Yeah.
Thought we did, Judge, I just couldn't remember now.
Count 18, for y'all that are wondering what that count is, that is one of the counts of false reporting to law enforcement that was dropped before the trial even began. Like the day that testimony and opening statements,
All right.
but
Is the state
before
ready to
that
proceed?
happened.
Defense ready to proceed.
Yes, Judge.
Then let's bring the jury in.
The case is, the defense, Riley, is not putting on a case. They rested. They brought the jury in. He asked if Megan Boswell was going to testify. She said nope. He dismissed the jury. They were on a break.
Everyone stand, please.
He put together the jury's packets. And bing, bang, boom, we're done. I think I have that same black puffy jacket that the girl who we're seeing her profile of
All right.
has. I think that's my same jacket.
All right.
That just, my zipper broke this
In
morning.
the criminal
I'm very
court for
upset.
Sullivan County, Tennessee, at Blumble. State of Tennessee versus Megan Boswell, defendant. Case number S72869. Date February 3rd through 12, 2025. Count 1, first degree premeditated murder. Count 2, first degree murder in the perpetration of a felony. Count 3, first degree murder in the perpetration of a felony. Count 4, aggravated child abuse. Count 5, aggravated child neglect. Count 6, tampering with evidence. Count 7 through 17, false report. Count 19, abuse of a corpse. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Jury instructions. Members of the jury. Count 1 of the presentment charges the defendant Megan Boswell with the offense of premeditated first-degree murder. This offense embraces the lesser-included offenses of facilitation of premeditated first-degree murder, attempt to commit premeditated first-degree murder, facilitation of attempt to commit premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, child neglect, attempt to commit child abuse, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 2 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offenses of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child abuse, attempt to commit child abuse, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 3 of the presentment charges the defendant Megan Boswell with the offense of first-degree murder in the perpetration of a felony. This offense embraces the lesser-included offense of facilitation of first-degree murder in the perpetration of a felony, attempt to commit first-degree murder in the perpetration of a felony, facilitation of attempt to commit first-degree murder in the perpetration of a felony, second-degree murder, facilitation of second-degree murder, attempt to commit second-degree murder, facilitation of attempt to commit second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, attempt to commit voluntary manslaughter, facilitation of attempt to commit voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, facilitation of criminally negligent homicide, child neglect, attempt to commit child neglect, assault, attempt to commit assault, and misdemeanor reckless endangerment. Count 4, the presentment charges the defendant Megan Boswell with the offense of aggravated child abuse. This offense embraces the lesser included offenses of facilitation of aggravated child abuse, attempt to commit aggravated child abuse, facilitation of attempt to commit aggravated child abuse, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child abuse, attempt to commit child abuse, assault, and attempt to commit assault. Count 5 of the presentment charges the defendant Megan Boswell with the offense of aggravated child neglect. This offense embraces the lesser included offense of facilitation of aggravated child neglect, attempt to commit aggravated child neglect, facilitation of attempt to commit aggravated child neglect, aggravated assault, facilitation of aggravated assault, attempt to commit aggravated assault, facilitation of attempt to commit aggravated assault, reckless aggravated assault, facilitation of reckless aggravated assault, misdemeanor reckless endangerment, child neglect, attempt to commit child neglect, assault, attempt to commit assault. Count 6 of the presentment charges the defendant Megan Boswell with the offense of tampering with evidence. This offense embraces the lesser included offense of facilitation of tampering with evidence, attempt to commit tampering with evidence, and facilitation of attempt to commit tampering with evidence. Count 7 through 17 of the presentment charges the defendant with Megan Boswell with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant Megan Boswell with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant Megan Boswell with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed, and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim, it is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony, however, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 2. First-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim. And 2. That the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And 3, excuse me, 3, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally have previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you will so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has previously been defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of these instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide is charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2. That the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2. That the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2. That the act of abuse resulted in serious bodily injury to the child. And 3. That the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant intentionally or knowingly caused bodily injury to another. And 2. That the act resulted in serious bodily injury. For purposes of this count, intentionally, knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1. That the defendant recklessly caused bodily injury to another, and 2. That the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5. Misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare, and 2, that the act of neglect resulted in serious bodily injury to the child, and 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation was in progress, And 2, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, new, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant. 2, that statement was made in response to a legitimate inquiry by a law enforcement officer. And 3, that the statement would concern a material fact about an incident within the officer's concern. And 4, that the defendant knew such statement was false. And 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix a fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20. Failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constituted a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1, attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2, attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3, attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4, attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5, attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6, attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17, attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1, facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminal negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19, facilitation of abuse of a corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or new means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. The person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on
Okay, I feel like we need a little palate cleanser and some commentary. Did y'all hear and understand that instruction? They only have to find that the defendant caused the death of the victim through a natural course of actions, okay? Uninterrupted, and not the fault of the victim themselves, in order to find her guilty of intentional homicide, okay? Do you notice what was not in that instruction? In that instruction, it doesn't say specifically that the state must prove the cause of death, only that the state proved beyond a reasonable doubt that Megan Boswell caused Evelyn Boswell's death. Okay? That's a very, 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 very important distinction. That's and it's we're listening to him speed read. I've never heard a judge read this fast ever, and I've watched a lot of trials, okay, where he is speed reading, but rest assured, okay, the jury has little notebooks with all of these instructions. Each jury member has the jury instructions in a notebook so they can go back and read them. Okay, that's why I wanted to just clarify for you that the state only has to prove that Megan Boswell caused Evelyn Boswell's death. That's important.
on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense, and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child abuse. 18, child neglect. 19, attempt to commit child abuse. 20, attempt to commit child neglect. 21, assault. 22, attempt to commit assault. 23, misdemeanor reckless endangerment. Count 2. 1, first degree murder in the perpetration of a felony. 2, facilitation of first degree murder in the perpetration of a felony. 3, attempt to commit first degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first degree murder in the perpetration of a felony. 5, second degree murder. 6, facilitation of second degree murder. 7, attempt to commit second degree murder. 8, facilitation of attempt to commit second degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child abuse. 18, attempt to commit child abuse. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 3. 1, first degree murder in the perpetration of a felony. 2, facilitation of first degree murder in the perpetration of a felony. 3, attempt to commit first degree murder in the perpetration of a felony. 4, facilitation of attempt to commit first degree murder in the perpetration of a felony. 5, second degree murder. 6, facilitation of second degree murder. 7, attempt to commit second degree murder. 8, facilitation of attempt to commit second degree murder. 9, voluntary manslaughter. 10, facilitation of voluntary manslaughter. 11, attempt to commit voluntary manslaughter. 12, facilitation of attempt to commit voluntary manslaughter. 13, reckless homicide. 14, facilitation of reckless homicide. 15, criminally negligent homicide. 16, facilitation of criminally negligent homicide. 17, child neglect. 18, attempt to commit child neglect. 19, assault. 20, attempt to commit assault. 21, misdemeanor reckless endangerment. Count 4. 1, aggravated child abuse. 2, facilitation of aggravated child abuse. 3, attempt to commit aggravated child abuse. 4, facilitation of attempt to commit aggravated child abuse. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child abuse. 15, attempt to commit child abuse. Count 5. 1, aggravated child neglect. 2, facilitation of aggravated child neglect. 3, attempt to commit aggravated child neglect. 4, facilitation of attempt to commit aggravated child neglect. 5, aggravated assault. 6, facilitation of aggravated assault. 7, attempt to commit aggravated assault. 8, facilitation of attempt to commit aggravated assault. 9, reckless aggravated assault. 10, facilitation of reckless aggravated assault. 11, assault. 12, attempt to commit assault. 13, misdemeanor reckless endangerment. 14, child neglect. 15, attempt to commit child neglect. Count 6. 1, tampering with evidence. 2, facilitation of tampering with evidence. 3, attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19. 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20. 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond a reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
Okay, while they're discussing that, I just want to tell everyone that this trial is going to have 2 phases, all right? The first phase is this part, the trial itself, okay, and the verdict. Now, should they find Megan Boswell guilty of the more serious offenses, the murder charges, then there will be a second, also any of the offenses. Let me just say that. They find her guilty on any of the charges, there's a second penalty phase. And because I'm not exactly sure if they will decide, like if they acquit her, I don't see how they can acquit her of any of the murder charges, yet find her guilty of the other charges. So at any rate, there'll be a sentencing phase. The jury is the ones that will be deciding Megan Boswell's sentence, not the judge. And I will tell you, it is my opinion that if it were the same for Leilani Simon, if it were a jury deciding Leilani Simon's punishment, that she would not have been eligible for parole. That's all. I think they got there with all the pre-made stuff, Nitka Ditka, because of the Hunter Wood's father testifying about how prior to even meeting Hunter or dating Hunter, prior to when she was looking for employment at the Chicken Shack, she told him that Evelyn was with Ethan. I think that's how they got to the premeditated part. What did Julie say? Because I saw, where's Julie? There you go. Julie and I concur. Julie said what I said. Yep, that's how they got to premeditation. That's what I think anyway. That's my opinion. I mean, I don't, that's what makes the most sense. Let me skip forward a little bit. We're a little behind. Oh, bruh, we're going to run out of...
There.
Here we go.
All right. Now, ladies and gentlemen, remember, when you go back there and you select a 4-person, this is the official jury charge, okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment at a separate sentencing hearing.
Okay, there we go.
You'll be provided with forms for all.
That was confusing. Okay, the murder charges, should they find her guilty of any of the murder charges, they decide her punishment. All the other lesser included offenses, the judge will do it.
All possible
Thank
verdicts
you,
in this
Your Honor.
case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict and your foreperson will sign and date the verdict form. Now, in your books, you don't have, oh, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of first-degree murder, or checkbox 2, guilty of facilitation of first-degree murder, find amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder, find amount $ blank, not more than $50,000. Or checkbox 4, guilty of guilty of facilitation of attempt to commit first-degree murder, find amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder, find amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder, find amount $ blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder, find amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder, find amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter, find amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter, find amount $ blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter, find amount $ blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, find amount $ blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide, find amount $ blank, not more than $5,000. Or checkbox 14, guilty of facilitation of reckless homicide, find amount $ blank, not more than $3,000. Excuse me. Or verdict form count 1 continued. Checkbox 15, guilty of criminally negligent homicide, find amount $ blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide, find
We don't need to hear the rest of this, I don't think.
box 11, or checkbox 11, guilty of attempt to
Just
commit
skipped
voluntary
ahead.
manslaughter, find amount $ blank, not more than $5,000. Or checkbox 12, find amount $ blank, not more than $3,000. Or checkbox 13.
I mean, here's the deal. All of the charges are important, right? They all, Megan did all of these things after she killed Evelyn. Okay. So they're all important. It's not that. It's just that I, I think probably the most I wonder which are the 3 ladies that you watch that are young. I feel like it might be Allie and MJ, but I can assure you, babe, I am not young. I just hit 48. Okay. My days of being young is over. It's not that these last charges are not important. They are important. They are all part of Megan's criminal scheme, right? But they're not the way that the instructions are not as complex as the more serious charges, and so that is what I wanted to really cover the most. I felt like that was the most important, but we're going to keep listening because I want to hear these closing arguments. Also, I already interrupted with the thing I wanted to tell you guys about the proceedings, which is that the jury is going to be, if they find her guilty of any of the murder charges, they will be deciding her sentencing, which I think they will find her guilty of. And I think it's going to be first-degree murder. And I think she's going to get life without the possibility of parole. That's my prediction.
Verdict form count 3 continued. Checkbox 6, guilty of facilitation of second-degree murder, find amount $ blank, not more than $25,000. Or checkbox 7, guilty of attempt to commit second-degree murder, find amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder, find amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter, find amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter, fine amount dollar sign blank not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter, fine amount dollar sign blank not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, fine amount dollar sign blank not more than $3,000, or checkbox 13, guilty of reckless homicide, fine amount dollar sign blank not more than $5,000, or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide, fine amount dollar sign blank not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, fine amount dollar sign blank not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount dollar sign blank not more than $2,500, or checkbox 17, guilty of child neglect, fine amount dollar sign blank not more than $2,500, or checkbox 18, guilty of attempt to commit child neglect, fine amount dollar sign blank not more than $500, or checkbox 19, guilty of assault, fine amount dollar sign blank not more than $2,500, or checkbox 20, guilty of attempt to commit assault, fine amount dollar sign blank not more than $500, or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, fine amount dollar sign blank not more than $2,500, or checkbox 22, not guilty, 4-person signature line date blank. Verdict form count 4, we the jury find the defendant Megan Boswell, marked appropriate 1. Checkbox 1, guilty of aggravated child abuse, fine amount dollar sign blank not more than $50,000, or
Oh, Margie, I'm so sorry to
checkbox
hear
2,
that,
guilty
babe.
of
Well, listen, I'll just tell you like this. You can always chill at the ward. We'll keep you entertained. I might be salty some days. I might be spicy some days. I might be salty and spicy. I might be a scatterbrain, but you'll never be bored, I assure you. If I'm the one talking now, I can't help it if we got to go over these jury instructions and they're a little dull. Okay, but if I'm doing the commentary, and you know what, speaking of, you know what I think? We've had some really, 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 really heavy things that trials, cases that we've been dealing with since the beginning of 2025, and we are only in the second month. I think we need a roast. I'm going to put up a post on the page on the page on my community tab, and I would like for you guys to give me suggestions of roasts. What I usually do is interrogations or testimony. So the deal is I got it. It's if you're going to suggest a roast or a criminal for the roast, not people from the tubes. I'm not roasting any creators or anything. It's got to be available on YouTube for me to share. Okay. Thanks. All right. Let's get back to it.
guilty of attempt to commit child abuse, fine amount dollar sign blank not more than $500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 5, we the jury find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of aggravated child neglect, fine amount dollar sign blank not more than $50,000, or checkbox 2, guilty of facilitation of aggravated neglect, fine amount dollar sign blank not more than $25,000, or checkbox 3, guilty of attempt to commit aggravated child neglect, fine amount dollar sign blank not more than $25,000, or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect, fine amount dollar sign blank not more than $10,000, or checkbox 5, guilty of aggravated assault, fine amount dollar sign blank not more than $10,000, or checkbox 6, guilty of facilitation of aggravated assault, fine amount dollar sign blank not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount dollar sign blank not more than $5,000, or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault, fine amount dollar sign blank not more than $3,000, or checkbox 9, guilty of reckless aggravated assault, fine in amount dollar sign blank not more than $5,000, or checkbox
Bruh,
10,
did he
guilty of
forget to
facilitation of
stop?
aggravated assault,
Am I?
fine amount dollar sign blank not more than $3,000, or checkbox number 11, guilty of assault,
Did I miss
fine
something?
in amount dollar sign blank not more than $2,500, or checkbox 12, guilty of attempt to commit assault.
Is
fine
he
amount
just
dollar
going to
sign
read
blank
all
not
the
more than
things? What's
500,
happening
or
here?
Checkbox 13, guilty of misdemeanor reckless endangerment, fine amount dollar
Oh,
sign
yes,
blank not more than
Ivelisse. I think she will
2,500,
be fine.
or checkbox
Fine.
14, guilty
I think
of
she will
child
be found
neglect,
guilty. Yes.
fine amount dollar sign blank not more than 2,500, or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect, fine amount dollar sign blank not more than 500, or checkbox 16, not guilty, 4-person signature line date blank. Verdict form count 6. We, the jury, find the defendant Megan Boswell, mark the appropriate 1. Checkbox 1, guilty of tampering with evidence, fine amount $ blank, not more than $10,000. Or checkbox 2, guilty of facilitation of tampering with evidence, checkbox the amount $ blank, not more than $5,000. Or checkbox 3, guilty of attempt to commit tampering with evidence, fine amount $ blank, not more than $5,000. Or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence, fine amount $ blank, not more than $3,000. Or checkbox 5, not guilty, 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of false report, fine amount $ blank, not more than $5,000. Or checkbox 2, guilty of attempt to commit false report, fine amount $ blank, not more than $3,000. Or checkbox 3, not guilty, 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of abuse of a corpse, fine amount $ blank, not more than $3,000. Or checkbox 2, guilty of facilitation of abuse of a corpse, fine amount $ blank, not more than $2,500. Or checkbox 3, guilty of attempt to abuse a corpse, fine amount $ blank, not more than $2,500. Or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse, fine amount $ blank, not more than $500. Or checkbox 5, not guilty, 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant Megan Boswell mark the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, fine amount $ blank, not more than $3,000. Or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances, fine amount $ blank, not more than $2,500. Or checkbox 3, not guilty, 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate.
Now look here, chicken lady. Hen Lou is living her best chicken life running that yard. Just, okay? Now, I believe she is behaved and well behaved at that. She's just being her authentic self. All right, Mrs. O. This is not the verdict, babe. This is the reading of the jury instructions. He's explaining how they are to deliberate. He's explaining all of those things. That's what's happening. It's just the son of a. They're gonna get a break, and then there's going to be. And then, yeah, and then the closing arguments. Okay, so this is where we're at. Now, for me personally, I think probably the most important jury instruction that was read was that the state only has to prove that through her course of action, Megan Boswell caused the death of Evelyn Boswell. They don't have to prove cause of death. Okay? That is a very, very important distinction. So this is what I think is going to happen with the verdict. I think that they're going to find Megan Boswell guilty of first-degree murder. And here's why. Not publicly, Tinkerbell wannabe. Tinkerbell asks, was there ever talk of pleading, like a plea deal? I don't actually, let me take that back. I don't know for certain what, if anything, she was offered. I know that for the last 2 years, Mr. Scott has been her attorney, and he stated during his opening statements that there is a part of the indictment respective to failure to report the death of Evelyn. But there was a part of that statute that was left out. And had that part of the statute been included, and again, this bears repeating, that is statute, Letitia. I'm looking at you, not statue, statute. There's a T at the end. There's a T in between the U and the E. Anywho, if that language from that statute had been included, he would have had Megan plead guilty to that charge, because their theory of the case, yes, they finished it, Scott. Their theory of the case is that this was an accident, that at some point Megan Hunter rolled over onto Evelyn and caused her death. But Megan didn't report it, and therefore Megan is guilty of not reporting the death. Now, that's all that I know as far as that goes. I don't know. This is, usually plea deals, kind of, if there's talk about them, sometimes they're reported, sometimes they're not. Like, we don't usually see what we saw with Sarah Boone, which is they discuss it quite publicly, what they're offering. If she pleads guilty, they're offering, I forget 15 years, right? And Sarah was like, nope, I'm taking my chances. I think I can beat this. Didn't happen, obviously. But usually we'll hear about it, but it doesn't like happen the way that it happened with Sarah Boone. You know what I'm saying? So if she were offered, I will say this, I would imagine that after Mr. Scott took the case, if there I don't know. I should just answer I don't know, because I really don't know. And she didn't, if there was, she didn't take it. But I do think that Megan Boswell, I do think the state proved this. I do think they proved premeditated murder. The reason I think that they proved premeditated murder is that it is Hunter Wood's father's testimony, respective to what she said before she even got hired at the Chicken Shack. It was in her pre-employment interview, where she told him, hey, yeah, I got a child, but it's no big deal. She's with Ethan, who she told everybody was the child's father. Let me check something right quick, because I don't think she answered me, but anyway, there's something I want to, like, I might want to tell you. I'm debating, so I'm just gonna leave it there. Anyway, I think that was very telling. I think that the state proved beyond a reasonable doubt the other charges as well, like abuse of a corpse. Okay. And I'll tell you how they prove that. Because the fingerprints recovered from various parts of that trash can only belonged to Megan Boswell. Now, if you believe that the trash bag and the trash can itself are the, for lack of a better word, murder weapons, that Evelyn went into that trash can alive, I still think that that falls under the category of abuse of a corpse because she left her there and actually put more trash on top of her. That the putting the more trash on top of her would constitute what what I say is abuse of a corpse. I think that they have her dead to rights online and making false reports. The interrogation interviews themselves, and I will tell you this, excuse me, even though the jury in open court, they, oh my, for Pete's sake. Oh, I guess this makes sense because it is 12 and they order lunch. So even with I totally forgot where I was. Let me think. Give me a second. I'm sorry, you guys. I got distracted by this whole lunch break situation. Oh, even though in open court only parts of those interrogation videos were played, the interrogation videos as a whole were entered into evidence. And so I think that so the jury they can go back and listen to that stuff. I think that they proved neglect in when they were going through items that were found in that, not the playhouse, but the shed, where they spoke about the condition that that chair was found in, that her clothes were found in, many items of clothing that were stained in the diaper region specifically, so I think they have her there for neglect. I think they have her there for neglect with the pictures from the trailer. I mean, look, um, everybody has moved at one time in their life, okay, from one place to another. And after everything is cleared out of that house, right? Even the best housekeepers have to go back and, vacuum, maybe do a mop. There's always like a little trash here and there, right? Like that's normal, what I would consider normal wear and tear to a dwelling, okay? What we saw in from the photographs of Megan's trailer is nowhere in the vicinity of normal wear and tear. In fact, it is 11 billion light years from normal wear and tear. It's not in the same neighborhood. It's not in the same town, the state, the country. It ain't even in the same galaxy. Okay. That place was horrendous. We also have the testimony from Megan's friends. And now I know that Mr. Scott made a big deal about they never saw abuse. They never saw neglect. That's not true. Caitlin Carter did. And so did Bailey. Bailey testified that there were more than a few times in Evelyn's life when Megan was visiting with her that she would have to ask Megan, do you think do you need to change the baby's diaper? Which is a nice way of saying the baby smells like they need their diaper changed. Then we have, like I said, Caitlin Carter at Chili's, who said that Evelyn appeared dirty and she could smell her from across the table. We have the babysitter's testimony, who, when she watched Evelyn, she went to change her diaper, and the diaper rash was so bad that it was blistered, and that there were it appeared to be like finger scratch marks through it. And she called her niece, who worked at who worked at a pediatrician's office, the same pediatrician's office that that Evelyn went to, that was her pediatrician. I can't tell you guys, because at the end of the day, that's I don't know what changed with Megan Boswell. I don't know what happened in her life that caused her to do just. I don't know that it was a complete 180, to be quite frank with you. And I say that because the whole reason that she was even living in that trailer to begin with is because she had previously been living with her father. And Megan's refusal to keep her room clean, and if she were able to do that to a trailer, imagine what she did to a room. Because a trailer obviously is much bigger than a single bedroom, and so it takes a little bit more time to get a trailer to look like that versus a room. Anyway, it caused strife between him and his, at the time, wife. Now they're apparently going through a divorce. I have often wondered if what changed for Megan was that trip to El Paso. I have wondered, and I don't think that it had anything to do with her being like still in love with Ethan necessarily, but I think that I would imagine that when Megan showed up, I mean, she was already there, obviously, when she actually showed up to the place where Ethan was staying, that she received a rather chilly reception, because clearly she wasn't invited. And I wonder if there was a discussion between Ethan, and Ethan did testify that they fought most of the time. But I wonder if there was a discussion between Ethan and Megan where Ethan straight and flat out questioned the paternity. Okay. And I think Megan had gone to El Paso with the intention of saying, I think you need to help me out with Evelyn. And when he started questioning the paternity, the help was not going to be immediate, because let's just follow this line of thinking, right? In order for Megan to enforce anything, any type of help, financial, visitation, etc., she would have had to prove paternity. Okay. Well, it's not like it's, immediate. There's a DNA test that has to be done. And it's not like the lab goes by, your last name, and that because her last name starts with a B, she would be put, they don't go alphabetically. Okay. They have stuff they've got to do, and they process they process the test the way they process the test. It's not, we were told, we didn't listen, Neat Noodle. And I'm holding this against you, Mr. Scott, who said paternity did not come out in trial as we hoped it would, because he said it would. Big old lying liar face. All right. I would imagine the reason ATS News sent me this is because she wanted me to see it. So give me just 1 second so I can upload something for you guys. Okay. It's part of the whole plea deals thing. All right. How can I show this? better. I don't really, hold on a minute. Let me upload it to Canva so that I can show you guys this screenshot and it's the way that it needs to be shown. I just need to like make sure it, because you can't see it like that when it's an overlay. Like it made it way too big. So give me just 1 second. So ATS News sent this to me this morning, and I waited. I asked, multiple times, like if it was okay if I showed this, but she hasn't responded. Okay, this came from Court TV. Hold on a second. I think their Facebook group, and it has to do with paternity. Now, I want you to keep in mind that at this point, all I'm showing you is a screenshot. It is up to you guys to decide how you feel about this screenshot, etc. Because I don't know how I can't, there's nothing for, I can't prove this in any way, shape, or form. Okay. Let me see if this is better. These are just, people make, here it is. Okay. So can you guys all see that? Let me read it. So this person asks, I have a question. Has anyone noticed the last few days the defense has been bringing the attention to a name, Eric Smith? I have, so I looked in my notes. I found a screenshot I had taken. Megan dated Caleb Stacy for a while. The mom, Erica Stacy, the sweet lady who made the shirt and blanket for Evelyn for her first birthday. She testified last week. She testified, I lost my place. Very sweet lady and very emotional about Evelyn. According to Caleb, Megan told him Eric was the father. Screenshot was taken right after the news of Evelyn came out. I am not saying Eric is the father, and neither am I. But I was curious to see if anyone else had noticed Eric's name coming up from the defense. So Caleb Stacy says, hey man, I saw Maggie last night. She'd been calling me for 45 minutes while I was at work trying to get me to take her home, trying to get me to take her mom. And then she bummed a ride to me, trying to get me to take her home. And I refused. I'm an ex-boyfriend, bro. She genuinely, I'm an ex-boyfriend, by the way, bro. She genuinely terrified me last night. Okay, let me take this. Let me take the chat away. And let me take this. No, I can do the chat. Let me just take this text away real quick. Let me hide this real quick. Oh, and she told me that Ethan is not the dad. I know some people think he is because the baby and him look alike, but I know the dad. He graduated in my class in high school of 2018, and his name is Eric Smith. So there is that. Make of it what you will. Decide for yourself. We were told, no, I don't want to delete. We were told that the father's name would come out in open court. Perhaps. Well, I think they know Country Life from that screenshot. I think they know from Caleb. Boss Lady says, I heard Eric Smith too. I heard from a local. Look, here's the thing. And I think that this is important. I don't know who Evelyn's father is, but I will say this. Her biological father is known. The paternity is known. But I would like to say this. I offer my condolences Can you imagine? Oh, MK Lynn. Maybe it will be the banger in closing argument, says MK Lynn. Maybe, MK. Maybe. Even if, okay, Patricia, even if I had a picture of Eric Smith, I wouldn't post it. And let me tell you why. Okay. Let's put ourselves, let's put ourselves in this, in the father's position. All right. You don't know that you have a child. All right. Or maybe at one point Megan might have told you that you might be the father, and then later said, but then all this whole time you've been under the assumption that Ethan is the father. Okay. So you don't know anything about your child. You've never met your child. You've never spent time with your child. And the only reason that paternity has been established and you find out that you were the father is because the mother stands accused of murdering that child. Put yourself in that person's position. Would you want your picture blasted all over social media? I wouldn't. I wouldn't. Now, I understand true crimes. I understand sleuth. I'm not judging them for what they do. I'm telling you what I'm not going to do. Period. End of story. That's it. That's all. I feel awful. No, we haven't missed closing arguments. They haven't started yet. We just listened to the jury instructions. The jury is at lunch right now. They will be back. And when they're back, closing arguments will begin. Then there will be more jury instructions read. And then, although I can't imagine more jury instructions being read, I feel like he covered everything, what's left. But this is just, I don't judge for the most part what other content creators on either this platform or any other social media platform choose to do with their channels. My name's Paul. That's between y'all. My name is Bennett. I'm in it. Okay. I do what I do over here, and that's how I do things. Other people, obviously, I don't, it's not my business. But for me personally, because of the circumstances under which this person would have found out that they're a father, I just think I'm not going to do it. I'm not going to do it. Melissa, that's a good question. Melissa says, I wonder if he can bring a civil suit like the Goldmans and Browns did against OJ. I mean, let me look. There's one way to know. Hold on a second. Oh, wow. Oh, wow. All right. In Tennessee, the statute of limitations for wrongful death claims is usually 1 year from the date of death. This means you must file a lawsuit within 1 year of the death, or the court will dismiss your case when the 1 year period begins. The 1 year period begins on the day of the injury that results in death, not the day of the death. If the injury occurs 1 or more days before death, the 1 year period begins on the day of the injury. Exceptions to the statute of limitations. Again, Letitia, it's statute. There may be exceptions to the statute, Letitia, of limitations under the discovery rule. This applies if the deceased person may not have known the cause of injury before their death. The reasonableness standard means the statute of limitations could begin accruing before the family knows about the true cause of death. So I would imagine that if there were to be something like that done, I it's possible that that this such set of circumstances would result in an exception potentially, because how could you penalize somebody who we don't know when paternity was actually established? So, um, we don't know when this person was told that they were the father of Evelyn. So I would think that that certainly sounds like there should be a room for exception. The court doesn't have to convict anyone in order for them to sue another person for wrongful death. The burden of proof in a wrongful death lawsuit is much different than the burden of proof in a criminal case. For example, with O.J. Simpson. O.J. Simpson was acquitted in criminal court of the murders of Nicole Brown Simpson and Ron Goldman. Yet the Goldman family was able to still civilly sue O.J. You don't have to have a criminal conviction because, I mean, think about it. I mean, you don't have, you don't have to have a criminal conviction in order to get to file a civil wrongful death lawsuit against somebody. We might still, Queen Bella. I mean, at the end of the day, what did he say? Really, what did Mr. Scott say exactly? See, this is where it gets important with let me go back to that. Let me just close this tab over here. Let me go over to the tubes. Let me go to my history, because I think after I watched it, it gets taken out of watch later. I think when you actually watch later, it doesn't hold it in the watch later. So I have to go through my history. Give me just one little tiny second. I feel like I watched that with you guys Saturday. So let me find Saturday. I'll watch a lot of, all right. See, the thing is, he is an attorney, okay? And we have to listen exactly to what he said, because what did he say? He said, I'd like to wait for that to come out in open court. That's what he said. Not through testimony. He just said open court. All right, here we go.
Today marked the third day in Megan Boswell's murder trial. Thank you for joining us this evening. I'm Terry Craig. Today's session covered more witnesses in the death of 15-month-old Evelyn Boswell, who was at the height of an Amber Alert in 2020 and was later found dead that year. The person accused being her mother, Megan Boswell. She's the only person facing charges.
Hang on, before we go down this rabbit hole, let me finish up this last rabbit hole that we were down. Okay, the question that was asked is, could it happen? And the answer to a civil lawsuit for wrongful death, the answer to that is yes, it could happen. Is it likely? No, it is not likely, because obviously it's not, it costs money. And at the end of the day, Megan Boswell does not have money, period. End of conversation. She's got a public defender. Her bail was set at $150,000. Okay. 10% of 150,000 is what, 15K? And her family has all this money, but they couldn't give, they could pay 22,000 for a vehicle, but couldn't pay, um, 15,000 for her to be out on bond. Which, I mean, even like at the end of the day, I mean, I guess, but at the, I feel like one of her family members might have done it for her, even if they were angry at her or whatever, all of the things, it is what it is. The Boswell family doesn't have money.
Charges in the death of Evelyn and has remained in the Sullivan County Jail since. Today, the court interviewed multiple witnesses once again. The court began this morning with more witnesses who knew Megan Boswell. News Channel 11's Ansley Daniel has been in Blountville at the courthouse since the trial began, and she's there now live to give us an update. Ansley?
Yeah, Terry, court actually just wrapped up a few moments ago, but I'm standing here with Megan Boswell's attorney, Gene Scott. Thank you so much for joining us again today.
Oh, you're welcome.
Well, first off, let's talk about the mistrial issue. Earlier, you made a motion for a mistrial. Do you think that there could be an issue with evidence that could come up again?
I think we sorted that out after we talked about the motion. My investigator and investigator for the DA's office went through the evidence in question. I think everything is sorted out at this point.
Now, earlier we heard from Ethan Perry. He took the stand today, who we now know is not Evelyn's father. Who is her dad?
I think that information is in the record and will come out, but I think I'd rather wait till it's said in open court.
And let's also talk about how everyone that testified today said Megan stopped bringing Evelyn around at one point.
After we talked about the motion, my investigator and investigator for the DA's office went through the evidence in question. I think everything is sorted out at this point.
Now, earlier we heard from Ethan Perry. He took the stand today, who we now know is not Evelyn's father. Who is her dad?
I think that information is in the record and will come out, but I think I'd rather wait till it's said in open court.
And
I think that information is in the record, and I think I'd like to wait until it's said in open court. That's what he said. So I feel like it is quite possible that it might be said in open court, and closing arguments count as open court. Maybe that's so, I mean, we'll see. We'll see. I don't know. I don't know how they're I don't know. I mean, certainly, I don't think that, hold on a minute. I can't imagine that he thought that the state would bring that out, because why would the state bring that out? I mean, they don't, it's irrelevant to the crime, right? That they're tasked with proving beyond a reasonable doubt. It's completely irrelevant to it. All that it would prove, and they don't even need it, because at the end of the day, Ethan testified that he subsequently found out that he was not the father of Evelyn Boswell. So all that really proves is, once again, Megan is a lying liar face who tells lies, who lives in Liarsville, who is currently in a three-way runoff between herself, Letitia, and Leilani Simon to be the mayor of Liarsville. And then we have another contender for the mayor of Liarsville in Lori Vallow, although I suspect that Lori would really rather be the governor of Liarsville in this, or the governor of okay, if it's Liarsville is the city, then the state would be the state of lying liar mouths. She would probably want to be the governor. She doesn't seem like the type of person that would be happy with anything less than running the whole show. So that's what I think. Anyway, I need a little bit, I need a comfort break, you guys. So let me go back. Let's go back to listening to, we were just about to start the cross-examination of, we were in the middle of the cross-examination of the medical examiner, the first medical examiner's testimony. So while I take a tiny little comfort break, let's I would imagine true crime T that he was informed. But I will I listen, I'm not the boss of anybody but me. I can't control anybody but me. But what I would ask is, I don't want the answer. I don't want to, unless it comes out in open court. I don't want, if somebody were to do all the research and searching and all the things, please don't put it in my chat. Unless it comes out in open court and it's part of the public record, I don't want to know. It's none of my business. It's not relevant for me personally. Okay. So I'm just going to leave it like that. And let's listen to this, the cross-examination of the first medical examiner. Ooh, MK. No, don't say sorry to that. That is not the same person who's been identified, and you're speculating, so it's not like that's different. I'm talking about if somebody were to go and sleuth and find proof of who the father was. This is different than a speculation. And you're talking about oh gosh, his last name is McLeod. He's Angela Boswell's boyfriend. I know, and that would be the cherry on top of the most effed up Sunday in ever. ATS, I've been looking for you, babe. I've been calling for you. I messaged you, which I think you just now replied, and you answered. Okay, good. I'm glad that you're, because I did ask permission, then I couldn't get the permission. So I thought, well, she wouldn't have sent it to me if she didn't want me to show it, but I can always ask for forgiveness. I'm not that kind of person, though. I'd rather ask permission than ask for forgiveness. I think it's easier that way, and I feel better about myself. But anyway, let's listen to this, and I will be back. Okay, here we go.
So there was an issue with the child's heart valve?
I wouldn't call it an issue, but yes, there was a defect in her heart valve.
I would think a defect, whether you take issue with the word issue or not, it is a defect. It's not good.
I don't know how to define good. I'm sorry.
Is a defect in one's heart healthy?
No.
Could that defect have led to the child's death? Is that possible?
It's a possibility.
You can't rule it out in this case, can you?
Based on the findings of the histological examination, looking at it under the microscope, I didn't see any changes in the heart. The decedent in the medical records had no symptoms. Normally it closes around age 4 or 5, and they're not symptomatic. They can be symptomatic, but it's usually documented.
So you cannot rule out that as a cause of death?
I think I ruled it out as a cause of death.
How?
She did not have any symptoms or signs of there being trouble with her heart.
Is that not something that could come on instantly with your heart?
Yes.
So how do you rule out that didn't happen?
There were no changes to that show the effect of that. It's common to see it.
Okay. How did you rule out sudden infant death syndrome?
Sudden infant death syndrome is a diagnosis of exclusion. If you're found in the manner that the decedent was upside down in the trash can, it's not sudden infant death syndrome.
You can't say that, doctor. If the child died of sudden infant death syndrome and then was placed in the trash can, that is possible, isn't it?
Usually they die around 9 to 10 months is the upper age, but yes, you're right. It could be a sudden death and then placed in the trash can.
It could be possible in this case.
I wouldn't rule it a sudden infant death syndrome.
Okay. You said they usually die younger, but sudden infant death syndrome goes up to the age of around 12 months, and there's really not a defined end to it, is there? It becomes less common. Is that right?
Yes.
Okay. And there are factors that can, we really don't know what sudden infant death syndrome is, do we?
That's correct.
Okay. But there have been factors determined that can maybe lead to that. That say there's higher incidence of SIDS with kids who have these conditions, certain conditions. Would you agree with that?
Yes.
Okay. Were you aware that there was an intrauterine growth restriction when Megan was pregnant with Evelyn?
Yes.
That can be one of the factors that leads to a SIDS death, can it?
Yes.
Were you also aware that as of her 10-4 visit, Evelyn suffered from acute pharyngitis?
I reviewed the records, but I can't remember everything that was in the records. I reviewed the records.
Would it help you to see the records?
Sure.
Yeah. We withdraw item 67, please. Okay, may I show this to the witness? Doctor, I would direct you to her October the 4th visit. Page 37 and 38.
I'm sorry. Is it towards the back? I'm sorry.
Yeah, 37 of 38, if you look at the page numbers on the top.
Oh, I see. I'm sorry.
Okay, one thing that I noticed in this exchange is his use of the word SIDS. And I believe that when he was cross-examining the second medical examiner, when he asked her that question, if another forensic pathologist used the words SIDS, then would they be incompetent? She said yes, not knowing that he was referring to this forensic medical examiner. And I agree with the comment that she used the term SIDS because he was using the term SIDS. And so she didn't correct him in saying, we don't use the term sudden infant death syndrome anymore. It's an antiquated term. We use the term sudden unexplained infant death, I think is what it is. I can't remember now. But at any rate, that was the one thing I wanted to say. And then I wanted to talk about this comment from Lucid Dreams, who says, anyone think it's possible Hunter really did roll over on Evelyn and Oh, excuse me. I'm sorry. I didn't mean to burp. Anyone think it's possible Hunter really did roll over on Evelyn and Megan lied to cover for him and protect him? No. And here's why. Because there was so much testimony and evidence um, to the contrary that Hunter never even met Evelyn. And that if that occurred, it is so unreasonable to think that Megan would also continue to simultaneously have a text exchange with Hunter wherein she's asking him to try and recollect any conversations he had with her mother, Angela, about going to, or anything that she might have said about, um, where is that town that starts with an M that just, the name is just like psh, out of my um, memory right now. I keep wanting to say Mordecai, but that is from the regular show. That has nothing to do with this town. And that why would that conversation take place at all? Like, she also asked him about anything out of the way that her mother might have said, and on top of it, Hunter, contrary to what Megan Boswell said during her interrogation interviews, did ask about Evelyn. He was worried about Evelyn, and I just I don't think that it's possible. And MK said something really great that is also a fantastic point. He says, yeah, but she didn't use it as a diagnosis. She didn't. You're correct. She didn't. That's an excellent point. Mendota, thank you. I just could not think of the town. Why would that whole conversation between Megan and Hunter take place if Hunter was part of it? It's a lot, to me, it's reminiscent of the hotel conversation between Leilani Simon and Danny, wherein Danny is questioning Leilani about the drive that she claims she took to go and purchase or to go and borrow the Oragel, when there was a whole container in the bathroom of that they both used and had access to, of Anbesol. Like, that just doesn't make good sense. It's like that. And why would she even entertain any of his accusations, frankly, in that hotel room that was under surveillance, and try to convince Danny that she wasn't lying if he's the one that unalived? I'm not going to use that word. If Danny's the one that murdered Quentin, like Leilani's defense, like Leilani, and let me just be clear about this. When that whole pointing the finger at Danny started, Leilani hadn't even been arrested yet. So I don't want to blame the, I don't want to blame that theory on the defense attorney solely, because it wasn't the defense attorney. It started long before Leilani was ever even arrested. So there you go. But that's what it reminds me of. It just doesn't make sense. And when the jury is back there and they're deliberating, they're told to use common sense. And common sense dictates that why would Megan cover for Hunter anyway? Honestly, why? If it was an accident, what need would there be? What's there to cover? And again, it doesn't explain why she told Hunter's father that Evelyn was with Ethan, and that was in her pre-employment interview. It just doesn't make any sense. Hey, Melissa, good to see you, babe. Good to see you. Just so you know, because I haven't seen you in chat in a minute, and I also haven't seen an answer from you. So I would love to talk to the doctor. And if you could forward her my email, I'm going to put it in the chat really quick. Give me just 1 second to do so, because I would love, love, love to speak to her. I have so many questions. So here's my email. All right. So let me push play on this. I have something I need to take care of really quickly. So let me just push play.
Let's hold on. Click. Okay.
Child suffered from acute pharyngitis, is that correct?
Yes.
Okay. Acute pharyngitis is an infection?
Yes.
Okay. And it's a virus, is that right? A viral infection?
It can be.
Okay. And that infection can progress toward the respiratory system, can it not?
Yes.
Viral pharyngitis itself can increase the risk of SIDS. Yes or no?
Yes.
I'm sorry. I sounded curt with you and I didn't mean to. I should have asked you a direct question. So please don't take offense at the yes or no. Child also suffered from gastroesophageal reflux. Is that correct?
Yes.
Okay. And what is that?
It's when the food comes back up through the sphincter, because food goes through the esophagus into the stomach, and there's a sphincter that keeps it from coming back up into the esophagus and to go down, continue into the.
I agree with what Ivy Lee says. Ivy Lee says, feel sorry for Hunter. She's trying to blame him, and her defense is also disgusting. I think that a lot of people have blamed Hunter. And this is why I say, like, I take the wait and see approach, because if I take a wait and see approach, it hurts nobody. If I'm wrong, nobody is hurt, right? But if I come out and I start making accusations and I'm wrong, that does hurt people. And I do think that the last item of evidence that the state admitted into evidence, which were the essentially the involuntary admittal into the mental health hospital of Hunter Wood, are particularly important. They're important for many reasons. The first being that the defense tried to sort of intimate that Hunter Wood was in the mental health hospital because he was trying to avoid testifying, while simultaneously blaming him for this. You know, there was the questions about Hunter having said something along the lines of his thoughts were being stolen, and that the only way for his thoughts to not be stolen was for foil to be on his head. Okay. There's a difference between putting foil on your head, all right, and wrapping your entire head, including your face, in foil so tightly that you can see the impression of your face, meaning that you can see where the eye sockets are sunken in, and yet the nose and the mouth protrude out in your jawline. Like, there's a difference in that. Okay. It's very, very frustrating. I forgot. I'm looking to see. She blamed everybody. Megan blamed everyone. And okay, so let's talk about this whole covering for Hunter, right? How does blaming her mother help Hunter? Jen Lu and I often steal and block one another's thoughts. Let me highlight this because this is so true of us. I frequently look, Dr. B and I refer to each other as each other's other half. She is the jelly to my peanut butter, or yeah, because I would, yeah. Dr. B will understand why I'm saying this. Of course it's jelly because jam don't shake like that. But she says, Jen Lu and I often steal and block one another's thoughts. We are like the LeBron James and Luka Doncic of the mental landscapes. Yes, we are. Dr. B is frequently in my head. She frequently says the things that I am already thinking out loud before I have an opportunity to say it. I have asked her repeatedly if she's going to be up in there to close the 1100 tabs that I have open, straighten up in there. It's very cluttered. And also, Dr. B is one of the few people that understands the filing system that I have going on up there. So yes. So, yeah. And here's the thing. I'm curious, I thought we might hear from Angela Boswell, but what could Angela Boswell's testimony really offer us? I mean, seriously, what could she say? Yeah, my kid blamed me for the disappearance. Yes, I am a drug addict. No, I didn't take the child. They reported the car stolen. They came and arrested me. I'm facing other charges currently, um, I was found, and when I was arrested for those the charges I have on me now, I was found with fake money and methamphetamines on my person. I mean, how could she possibly help? It wouldn't. She's like one of those witnesses that is like a wash. She's not going to really help the state, and she's not going to really help the defense. I mean, she can't really bring anything to the table. She really cannot. She doesn't have anything pertinent to add. How much longer are they going to be on lunch break, y'all? Because I'm getting hungry as well. I mean, exactly, MK. Like, there's nothing that she has really to offer. The only person that I wanted to hear from that didn't testify was Hunter. If Hunter could have brought some good testimony to the table. He was the one that was running around with Megan the whole time that Evelyn was quote unquote missing, right? And that's another thing. Okay. About Hunter and she was covering up for him. If she was covering up for him, then why is it in her first interview with law enforcement that the detective offered to go and to call Hunter for her, right? And what did she say? No, thank you. I'd like for you to please find out if Hunter has a order of protection against him, because if he does, I don't want to be around somebody like that. Well, you murdered your child and stuffed her in a trash can and kept her in a playhouse and never reported her, just left her there. I don't want to be around somebody like you either. How about that? But yeah, like, why'd she do that? What was the point of that if she was trying to cover up for him? We know that Hunter wasn't in the hospital voluntarily because they admitted the last piece of evidence that was admitted by the state was a court order from Bristol, Virginia, making Hunter submit to a mental health evaluation. He was admitted to the mental health facility involuntarily. It's in that paperwork. I'll rewind it for you. Let me share this tab instead. I'll let you listen to it.
That's the way it is.
Alice, what are you doing, psycho?
Yes.
So I thought we'd take that up before I brought the jury in and had to send them back out.
Hold on.
Leave the charge to the jury.
All right.
Court stands in recess.
Oh, for Pete's sake, Jen Lou, come on.
Which will be painful. That is outside of her. You argue. Will you have other proof?
No.
No. I know it seems like you got the jury out. But what I do is
Oh my God.
Everyone stand, please.
All right, we're about to hear it right now. Hopefully, I think I skipped to the right portion.
You may be seated. Thank you.
All right. Okay, ladies and gentlemen, one thing I omitted to do a moment ago. Yesterday, during Dr. Malushnik, did I say that right?
Yes, it is.
At the very end of her testimony, she answered a question and then gave what I'm going to call a parting shot, that the answer was no, and that the baby would have to have been murdered some other way. Y'all remember that?
Yes, sir.
I'm going to instruct you that last phrase, you're not to consider. That is outside of her expertise. Okay? It's a legal term, not a medical term. Does everybody understand that? Can everybody put that murder in some other way out of their mind and not consider it? If you can, raise your right hand.
They're back.
All the jurors raise their
Hold
right
on, let me just, I want you to hear this,
hand.
Lucid, 'cause it's
It
important.
is not actual identity.
Court stands in recess.
What the fuck? Where is it at? I literally just played it.
They were that this was a homicide.
Hold on a minute. They're going to talk about it at the beginning of the day too, and they're back. So they're getting ready to do closing arguments, but I want you to be able to hear this because it's important.
Scott's argument regarding and
Evidence.
I can't find it right now, and I don't want you guys to miss any of it. So let me get us to where we need to be, which is over here. And I'll go back and find it at the end of the day. But it is there. All right, here we go.
Standing right there. I'm gonna stand in front of you, but I don't want you crossing the end of the table.
Why?
My face.
Judge, we may have to have a sidebar before we start.
That's not what I said.
Hey, Lucid. I do think, hold on. Listen, I'm curious of what other people think too. And I got what you were trying to do, babe, and I hope I wasn't coming across harsh. I was just answering you, like, in my opinion, why that can't be. You know what I mean? So that's all. I hope I didn't come across as harsh or mean or anything, because I certainly didn't mean to be. Sometimes when I get really passionate about something that I feel, that happens. I'm so sorry if you felt like I was coming at you, because I wasn't, and I apologize if I made you feel that way. That was not my intention.
Well, the problem with the laser generator is because it's made for LCD screens, it'll bounce off of things. I don't think it was intentional. No, I didn't. Yeah. Well, we can practice it to make sure it works, and it was hitting the wall over there, and we're like, she sure did, including,
All right. Is the state ready to proceed with closing?
Yes, Your Honor.
Defense ready?
Yes, sir.
If the jury's ready, let's bring them in.
Oh, they did it this morning. It was at the beginning of court. So after they bring the jury in for the day, the state introduces that piece of evidence, and then the state rests. So yeah, I found it before. I don't know why I can't find it now. I don't know what's going on with my fast forward and search game, but it's off. Pause game's probably still good. We'll find out. All right, here we go. They're bringing the jury in, and we're going to hear the closing arguments.
Now, I am going to say, hey, Kyle, hold on.
Okay.
Sorry. Let me put this down here so y'all can hear me. Can everybody hear me? If there is any outbursts at any time during the state's closing, the defendant's closing, the state's rebuttal, I'll clear the whole courtroom. All right? Now we have the jury.
I mean, well, I think that the defense's argument about that is that if Evelyn was if Evelyn was alive when she was placed in that trash bag in the trash can, right? And therefore the trash can and trash bag would be the, for lack of better word, y'all, murder weapons, then how can Megan be charged with abuse of a corpse? That was really his argument. And so I think that that's probably more the reason. I think in the that's the legal reason. Obviously, for us and Megan or Evelyn's loved ones, right? It matters to them because it makes it more heinous. I think that if she were alive when placed that way, um, I think it matters to them. But I legally, um, I don't actually think that it matters really. If Evelyn, of course, if the jury believes that she went into that trash can alive, then that would suggest that's further evidence that supports premeditation because she would know, because Megan would reasonably know that placing her in that trash can upside down with a blanket and foil wrapped around her head so tightly that it likely caused it hindered her breathing if not stopped it completely, right? Um, that's that's evidence of premeditation, but it's also evidence of um, aggravated child abuse.
You've got exhibits 1 through 5 and 93 separated, right? 93 also? Yes. Okay.
Welcome in, everybody. We're about to listen to closing arguments. I appreciate all of you guys being here and watching with us.
I need exhibit 3. It's a video.
This is probably going to be difficult again to hear, but I'm glad that we're all listening to it together, and I hope that Evelyn gets justice. I really do.
Everyone stand, please.
Counsel are intended to help you and understand and reason. If attorneys will have an opportunity to get this. I'm going to leave this up if that's okay, Your Honor.
Right.
Thank you. So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6. It covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase. But they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law. But they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Oh, sweet Jesus. Man, what is it she shouldn't have said? You said all those things. What's the problem, bruh?
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, but the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, John.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also can make mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident, or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years, in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down, in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the Chicken Shack, to December 8th. Evelyn Boswell's 12-month well visit. Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her, so they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by. Because I know that's a question we have all had. 2.5 months goes by. 2.5 months. But now we know. We know why. Because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But time continues to pass, and you've heard witnesses, and particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think that something doesn't feel right. Just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day, and Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood, and Megan Boswell's there, but there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you were alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house. House that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger. Not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. Now I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back, I'm trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy, and so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with her mommy, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated there are, maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different, then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was.
Y'all, this is Court TV on Court TV's end. It's not on mine, and I can only assume it's because of the picture. Hold on.
There she is. Evelyn Boswell sat there in that trash can for 2.5 months. And her mom discarded her, not just Evelyn, but everything that was associated with Evelyn. Everything. Because she didn't need it anymore. Everything. She didn't need that stroller anymore, so she left it behind. She didn't need the clothing. Do you remember all the pictures that came in and all of that stuff that was in that shed? Because she didn't need it anymore, because she knew where Evelyn was. The defense wants you to believe that Hunter Wood is the one that backed Megan's car up to that shed? In the middle of the day. In the middle of the day, Hunter's just going to go over there. He has a truck. The testimony was that Hunter had a big truck. Now, why in the world, if he had a truck, I mean, this clearly took more than one trip. I guarantee you. Look at all this stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tommy came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Omani's house. Tommy's house, up on the hill, in the middle of the day. Is that reasonable? What is reasonable? How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed, because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house, and so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand, and you heard Megan Boswell admit that she knew Evelyn was dead. She was telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment? And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. Think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? But she's sad today? She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child? What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can, and she's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing. Still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things. You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA. Let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you couldn't look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell, that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture of DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory. Or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it? Under the rim. Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag. And it was forcefully pushed down. Compressed, I think is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if the child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malushnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide, and that Evelyn Boswell died from some sort of asphyxiation. So, suffocation, I guess, is the easiest way to say it. So, if it was not for, say, the position of her body upside down in the trash can, that could have killed her. Well, say it wasn't that. Then maybe it was the blanket that was pulled up over, remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve, so where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil in her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count 1, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser-included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. And again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count 1 is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you there is nothing about this case that is not premeditated. Count 2 and count 3 are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child was under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, The defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. But I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott.
Before we, I'm sorry, you guys, before we get to the defense's closing arguments, I would just like to say this. So the poll has been closed, and the question was, did the state prove the charges beyond a reasonable doubt? 92% of you said yes, 7% of you said no. The poll was complete with 81 votes. There are 148 of you people in here right now. If you vote, you're not going to be called to jury duty, for Pete's sake. Lord, how could you not vote? But thank you to the people who did vote. Maybe people didn't see it. Maybe they're watching on their TV or whatever, not at their phone in a place where you can vote. I'm just giving you a hard time, but I do want to assure you that if you do vote in a poll on YouTube, you will not be picked for jury duty. Also, this would be my closing argument in this particular order. And with that, I believe we are now ready to hear from, the defense. Let's go.
You may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case, and Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. The jury instructions will tell you that this case is not about your emotion. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth a theory that you should convict her of first-degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also, technically, would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She had witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well checks. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she thought her diaper needed to be changed, and once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville up into December.
I'd like to say something right there because that hit my ears wrong, and I'm sorry, but there's times when I just have to interrupt. Not buckling your child in their car seat. If you drive with a child not buckled into their car seat and you're in an accident, rest assured you will be charged with child neglect.
December sometimes, and by that point she acts disassociated. She's not normal. She's saying I love you over and over again to her. So, again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect.
Also, I feel it incumbent upon me to clarify for the audience that clearly Mr. Scott here is using the Letitia Stout definition of disassociated and not the actual definition of disassociated.
What? Mr. Horn questioned her. She describes things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about a home life, watch the video with Agent Fraley. Her mom was let in there in stripes, a jail uniform. What kind of home life was that? And then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, that Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name is, I can't remember his name obviously. That's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out of anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso till I see his car in the parking lot, pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swallowed her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they have? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he said, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. And the young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Schmidt and Dr. Malushnik. Now, Dr. Schmidt, I asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And a diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Malushnik, or Dr. Schmidt knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive or dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massengill brought up that I brought up tongue tie. I brought up tongue tie, I brought up GERD, I brought up an infection she had, because all of those things can lead to the onset of SIDS. That's the research, and Dr. Schmidt agreed with that. Now, I want to tell you something about Dr. Schmidt and Dr. Malushnik. I think Dr. Schmidt she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Smith was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malushnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find with some type of certainty that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, Doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear she could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. McLustick come in with a preconceived notion of that's what happened. Now, the state has to prove to you the cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Schmidt leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. And it also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called and reported it? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false reports. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about it. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How can her one fingerprint be on a piece of tinfoil? Can you all see this roll? Maybe like this. Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. And there's food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen. Your DNA is all over the house. Your I said DNA, actually fingerprints. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Maxengill made a statement, and I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint experts say that it can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement with Agent Fraley. February the 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's. It could be at Tommy's. Why would you say, if you're trying to lie to them, or perpetuate this lie like Miss Massengill tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these two places. Says, I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case to you. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some rolling over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Massengill talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. Now, what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone to specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter, and it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at the texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child, but I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation and start texting it, say, oh no, I didn't do that. Look at my text. I texted her, she's told me this. It's a convenient thing for him. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document admitted this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your questions. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions about any elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt on this homicide count. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons, and I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you'll come to the right decision. Thank you.
Thank you, Mr. Scott. General, you may close on.
Pardon me, General, before you close. All right, first of all, use your inside voice, sir. I get that you're passionate, but at the end of the day, there's more people. I know you're only really speaking to the jury, but the rest of us are wearing earbuds. So if you could speak in an inside voice, we would all very much appreciate that. The last thing he said about the text exchange between Megan and Hunter, I will respond thusly.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
The doctor that testified that he had some really choice, incorrect descriptives for her, I don't believe that she was biased. She benefits in no way, shape, or form if Megan Boswell is convicted or if Megan Boswell walks. She has no vested interest in the outcome of this trial. And more importantly, I would suggest that her reputation and credibility are always on the line anytime and every time she performs an autopsy, anytime she testifies in court, etc. She has zero reason to get up there and make up some cockamamie bullshit about how Evelyn died. And at the end of the day, I will tell you this. My mini Bindi had a heart murmur. She had a little hole in her heart when she was born. It is in the part of the heart. It's a flap that did not close because she was born via C-section. She's the only one of my kids that had it, but the location of that heart murmur, okay, is in a place where the muscle would grow over it anyway, and it did end up closing. But up until it closed, hey, guess what? Mini Bindi was diagnosed as a healthy baby. In all of her well visits, they referred to her as a healthy baby. And I would submit to you guys that Evelyn Boswell might have had some little issues, but generally speaking, she was a healthy baby. Megan was not covering up for Hunter. That's utter and complete poppycock, and he just insulted the jury's intelligence. He would have been better off not saying a dang thing about that text exchange than to say what he did. That made zero negative sense. I mean, negative 11 billion cents. What rational mind could come up with that? Sir, I really, 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 really hope that you stretched before making that reach. You're going to pull somebody or something. Sorry, I'm reading the chat. Ridiculous. Absolutely ridiculous. Let's hear the rest.
On behalf of the state.
Thank you, Judge.
Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends, every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great-grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, that was the point, which she decided, hey, I'm going to be truthful here. No, it wasn't. No, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, when Agent Gratz testified, General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So they're the ones who suggested it. And then very conveniently the next day she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected him. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this just pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil, and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack. And that she meets Hunter Wood. You know, that Hunter Wood. The one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. Remember the other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. Wanted Ethan Perry to step up. I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd. 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have her. Evelyn's sick. She's got the flu. I can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. Her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture. And I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting it out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one.
General, we're all over here at the ward sitting here just shocked with our jaws on the floor that he even tried that reach. We agree with you. Please continue, sir.
And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand, and said, oh, yeah, I remember when I saw Hunter and Evelyn and Megan together? I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No. Again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember. But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed? Well, maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her property and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier and in doing that she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it? Maybe that's why. And again, in this particular case, you heard from Agent Gray, what does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her that she analyzed, not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. Remember I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just 2 doctors about Evelyn's condition, about what kind of a child she was. You heard from 3 doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No. Her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern. Not, Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who die in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet, They want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently. The first one. No, it's not a possibility. You decide this case on the evidence that you've heard and the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. And all the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tin foil. This isn't foil like you stick around a baked potato and stick in the oven. You saw it. You saw the photographs. And the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it was sitting down in the trash can and somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket, so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that, as Mr. Scott said, is really, sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All those people. Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. And that's a pretty good description of it. It's a web. And it traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it into here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could do Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there, Detective Perez and James Lewis interviewed her. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions, for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell was guilty. First-degree murder, a false report, tampering with evidence, and a failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, General. Like to see the attorneys. Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them.
Dear Megan Boswell, your goose is cooked because if I heard correctly, they just chose the alternates, and the alternates were 3 men. If I'm not mistaken, there were, what? I think they picked 14, and I believe that there were more women on the jury than there were men. And I believe Megan's fate is going to be decided by the majority of the jury being women. Megan, your goose is cooked, Shug. They finna convict you, and you finna get life without the possibility of parole. let's continue just to make sure I didn't miss something and we didn't miss anything. And then I'm going to play something for y'all real quick, and then I'm going to let y'all go, and we'll be on verdict watch. Here we go.
The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49.
We will not be listening to back on page 49 with the jury instructions. This is what we are going to be listening to. And even though Neat Noodle has specifically and directly instructed me not to do this just for her, as much as I love Neat Noodle, she is not the boss of me. And if I want to stream something just for her, I will. This is the interview that Megan gave where she talks about Hunter's involvement. It was not played by the state. It was played by the defense. All right, here we go.
Does any juror have anything to report? If you do, raise your right hand. Does the record reflect that none of the jurors have raised their right hand? I believe we were beginning cross-examination. Mr. Scott?
Yes, sir.
You're up.
Good morning, Mr. Fraley. How are you?
Good morning, sir. Fine, thank you.
I want to start where General Harper left off yesterday.
Okay.
You were asked, you conducted an interview of Megan on February the 25th of 2000.
Yes, sir. Myself and Detective Licklider from the Sheriff's Department.
And in that interview, you you talked with her about the child being dead.
Yes, sir.
And some other things.
Yes, sir.
Judge, this time would ask to show that video.
So hold on.
But when you left, how long would you go?
Now we're good.
Oh, not day you in. You know this, okay? You know that. This is the last day. If you had,
tell you where I think you all would.
I would, and we'll bring it down. Yeah, but don't let me bring her on, man. Don't let us on like this going too long. Okay? This is for your baby. This is to give her the proper attention. Where's she at?
There's only two places I can think of where she would be.
Where's she
She
at?
said they put her somewhere closer. I think she's somewhere at Dad's or at his house.
Okay, his house?
Maybe somewhere like, you know, that like the dog store. I think she's either there or she's somewhere at Dad's. Or she's somewhere close.
Underneath the dock at Hunter's.
I don't know if she's underneath there. I'm just,
Is that what you're trying to tell me? I'm not putting words in your mouth.
that is just my theory. She has to be
No,
more
we're
places.
not looking at theory, son. You need to bring her home.
He said that she was somewhere close, so like two places I can think that he would take her.
You're honest with you? Okay, but you know this part.
I don't know for sure. I'm trying to help you all. I swear I am at this point in time.
This is the ending, okay? Let's bring her home, so bring her home.
There's a bunch of places I think that he would even have time to take her. She wasn't going very long.
Well, regardless of time, there has to be a reason that you would know that, okay? Because that
He said she
is
was somewhere close.
in that time. There's only X amount of places she could be, okay? But you're specifically narrowing down those two places, right? Do you know?
He said she was somewhere close.
Help me with this, Megan. When he took her out with the driver, how was she dressed?
You know that picture I have of her? She's in her old penguin suit.
Does she have the penguin suit? Is she wrapped up in her blanket?
She was wrapped up in
Did you give her to him?
picked her up
You picked her up, where was she?
on the bed. I held her for hours because I didn't want to let her go.
And that's okay. We need to bring her home. Okay? We need to bring her home today. Just tell us where we can go get her.
I don't know for sure. I told you, or I think she's at.
Okay, hold on. You held her for hours.
Yeah.
She was in what? How was she dressed?
You know that picture of me and her were sitting outside the trailer and she was smiling and she has that little purple thing on.
Yes. And she was wrapped up in a blanket.
Like a dark colored blanket. A thick fleece blanket.
And he took her from you? Where did he put her? What car was he driving?
My red car.
Your red car? Did he put her in the trunk?
I don't know. I didn't go out
Did
there.
you go outside with him?
No.
What time of day was it?
It was close to the dark.
Was it close to dark or was it
It was
dark?
close to the dark.
What day was it?
I don't know what day it was for sure, to be honest with you.
So, how long was he gone?
Less than an hour.
Was it 15 minutes or 30 minutes or 45 minutes?
Maybe like 45. He kept saying she's somewhere close by.
Did he ever take you back to where it was? Between then and now? And this was in December, early December. Was it after you started working at the
It was
chicken?
after summer.
How long after?
Not too long.
You started on Monday, right?
Right?
Was it Tuesday?
No, it was a
Wednesday?
week or two after.
It was a week or two after.
Closer to 2 weeks.
So about December 10th. What do you remember about that day? Did you wake up or what happened?
I don't know. I rolled over on her. I don't think I did. I think he did it. It was an accident.
So he was sleeping in bed with you? Was the three of y'all together? In the bed?
Between us.
Okay.
I should have put her just on my side. I slept with her almost every night of her life before that, and I never once rolled over on her.
But when you woke up, she wasn't breathing. Is that what you're telling us?
Her head was like buried in her pillow. She wasn't breathing.
Okay. So, there. So do you tell him, hey,
I was panicking. He was like, well, you can't be calling when we're both going to
why
go to
can't you
jail.
call someone
Because he said we were both going to go to jail if he didn't care of it.
for her? For her just rolling over, or you rolling over on him? Or on her?
I don't think I rolled over on her there. I don't know if he did an accident or what, but like I said, I slept with her like her whole life before that. With her up against me right next to me, I never rolled over on her.
We need to bring her home, man. You need that piece. Mom needs that piece. Everybody needs that piece. We need that piece. Help us bring her home. You're the only one that
I
knows.
told you all the only places I know he could have went.
Where? Name it.
My dad's in his house.
When you say your dad's, where are you talking about your dad?
I'm really crazy.
Because he wouldn't have taken her inside the house and said, hey, Tommy.
Well, I don't know. I just know there's
Why
a
would he take her back to Tommy's?
He said he was going to take her somewhere close.
See, I don't think he would have taken her to Tommy's. That's too much of a risk. Why would he do that?
I don't know.
What if your dad would have caught him? See, I don't think she went there.
Look, can you all just please check and then check?
We're going to
her
check
place?
everywhere we believe she may be.
Okay.
But again, we need to understand where she's at.
I don't know for sure where she's at.
When you say for sure,
I just have guesses and I've told you two what they are.
and why has Hunter never spoke to you about this?
I don't want to
When
know.
he came back, what did he say?
I put her somewhere close.
Did he say how he put her?
No, I
Did he
didn't
throw
want to
her in
know.
the trash can? Did he throw her in the lake? Did he bury her?
I didn't want to know.
What did he say?
Just that she was somewhere close and not to worry about it.
Megan, you've lied to us for 6 days now. I need you to be truthful with me today.
I am being truthful.
No, just hear me out, okay? I need you to be truthful with me today. We're getting there. We need her brought home. She don't need to be laid out in the woods in the cold anymore. She needs to be buried. She deserves that. You need to help us bring her home. Please. Tell us where she's at.
I don't know for sure. I really don't. I didn't want to know.
I think you do, Maggie. I think you're scared to tell me.
I don't. I told you go into places I think she needs to be.
When you say the boat dock, what do you mean by the boat dock?
I don't know, maybe he buried her there or what.
Did he mention the boat dock?
No, but he said he took her somewhere close and he wasn't gone very long.
Did he drive away with her? Was she placed in the trunk?
I don't know for sure.
You didn't look out the window?
No, I didn't want to.
Who did you call?
Nobody. I was scared to call anybody.
Did he call you while he was gone?
No.
And it was dark. Close to getting dark.
It was dark by the time he got back.
It was light when he left and dark when he got back. We need to bring her home. If she's laying out there somewhere, she deserves better than that.
I don't know. I told you go into places I could think me to take her.
Okay.
What are you all going to tell my dad when you go to search his property?
What should we tell him?
I don't know.
Is she buried on that property?
I don't know if she is or she isn't. I really don't know. There's a village places I know that he didn't have time to go to. They
Did
could
he ever
have.
take a shovel?
No.
Did he take a trash bag? Did he carry her out in that blanket, a box, or a box? Jump into the
I
box?
stayed in the bedroom. I just had her wrapped up in a dark colored blanket.
How big was this blanket?
It was like a normal size, like fleece blanket.
So when you say wrapped her up, so you describe that to me.
Like, you know, you swaddle a baby.
Okay. So did you leave her face exposed?
So it sounds stupid, but I didn't want her to be cold, so I wrapped her up in a blanket.
So she was her whole body was wrapped up.
Except for her face. You know how you swaddle
So
a
her face was
baby?
open.
You know how you swaddle a baby?
Mm-hmm.
So I wrapped her up. I didn't want her to be cold.
We don't want her to be cold anyway. She's still out there, and we need to bring her home. And you can help us with that part.
There's only two places I'm trying to go look for it. I need that.
So Hunter's dock. Underneath Hunter's dock.
Or just around the dog.
Okay.
I don't think if he did take her to his house, he's not stupid enough to, you know what I mean, just put her somewhere inside the house. His dad owns property right next to that place too.
How long did you hold her?
For a long time.
All day?
I didn't want to let her go.
How did you know she was dead?
Because she wasn't breathing. Her eyes were open.
Her eyes were open.
She wasn't breathing. I tried to give her CPR, but she was already gone.
How did you try to give her CPR?
Mouth to mouth.
What else?
That's it. I just held her leg.
She gag or anything while you were trying to give CPR to her?
No.
How did she feel?
What do you mean?
Was she cold?
No.
She's still warm? What about the color?
She was still
Was she blue?
No, not really.
What did she look like?
Just like her. As the day went on, she got colder and so I put her in the blanket because I didn't want her cold.
And you don't remember what day that was?
No. I know it sounds bad, but I'm just trying to block it out of my memory as much as I can.
house. So where does that connect to? Where does the back of his property connect to?
I don't know.
So you,
Yeah, that's what's there, and then that creek is like right up to the asphalt, stuff like that.
you're shooting one of those asphalt piles.
I don't know, I really don't.
Is there a lot of asphalt piles on his property?
I don't know if there is any or not.
So I've not been out there, I don't know, I'm asking. Again, that's what I'm trying to do, man. Help us bring her home. She don't deserve another night out there in the cold alone. She needs to be brought home.
I don't know, I really don't. I don't know if he took her in the trash can or not. When he came back, it was gone. I didn't want to ask.
Your trash can and the trailer was gone.
I didn't want to ask.
Was there a dumpster anywhere there close?
I don't know. You have to look.
No, to where you, when you lived there. What did you normally do with your trash?
Took it to the road and then the trash can.
So you said took the trash can, the inside trash can, the outside trash
The
can?
inside.
Just when you kept in the kitchen?
I don't know if he took it with her or not. I didn't want to know.
You said you sit there and looked at her.
Yeah.
When you woke up and she wasn't breathing, tried to give her CPR. What did her eyes were open? Were they bloodshot?
No.
Were there any bruising around her eyes?
No.
She just looked like she always did, just like she was at peace asleep.
No, her eyes were open.
Her eyes were open. Not bloodshot or bruised.
Not really, no.
Because I can't help but think that's probably a lasting image that you think about Evelyn. So you know her bloodshot eyes were bloodshot or not, or black, and you're not saying they were.
No.
Okay, that they were just open.
I didn't want to let her go. She wasn't cold, and when she started to get cold, I thought that the blanket around her, so I didn't want her to go home.
What woke you up? Was she choking or crying
No. I just woke
or
up.
kicking?
No.
If we talk to Hunter, what will he tell us?
The same thing he's been telling you, that he's never met Evelyn because he told me not to tell anybody that he would go back to jail.
If he has never met Evelyn, how do we make that connection that he has?
I don't know.
Was he ever out in public with her? During this time, how long had you all started dating?
Not long.
Talking about not long, like a week,
Yeah.
a couple of weeks, a month? So prior to you starting at the chicken shack,
No, I didn't know Hunter.
you didn't know him. So the first day you met him was an interview for that job?
Yeah.
When was that?
I don't know.
You started on Monday.
Right. I think it was a couple of days
The day
before.
before, like on a Friday or Saturday?
It was probably like a day or two before.
Did you go there in person and fill out an application?
Yeah. Evelyn said the
And that's the
door was
first
locked
time?
by Bailey.
Okay, and that's the first time you ever saw him.
Mm-hmm.
What happened?
I just filled out an application, that's it.
Did he ask you out on a date? Is what I'm getting
No, not until I started working there.
So you started working, he said, okay, you're hired. You started working on December 2nd, on a Monday, correct? And then start flirting at work.
Oh my gosh, y'all. First of all, I didn't start talking while I was muted because there was like this music in my ear and I had forgotten that I left the um, tab for the current trial for the live stream for the trial open. And I was looking around everywhere like a crazy person for a phone to be ringing. All right. So, what has Evelyn admitted to? Or, excuse me, I'm sorry, I'm reading the dadgum title. Let me start again. What has Megan admitted to that we know is supported by the facts and evidence? All right. 1, Evelyn was found wrapped in a blanket. Now, was she swaddled? No. And here's why. Because when you swaddle the baby, when they teach you how to swaddle a newborn at the hospital, never, never, never do they tell you to cover the baby's face tightly. Okay. Let's start there. So that part of it is a lie, but she was found in the blanket that Megan said she would be found in. Number 2, she was found on her dad's property, just exactly like Megan had said she would be. I think at this point in the investigation, Megan is kind of getting tired of the lies, and I think she just wants it to be over with. If I'm being honest. All right. Number 3, Megan said that Evelyn would be found wearing her little purple fleece footed PJs with the penguins on it. That's exactly what Evelyn was found to be wearing. It took a while, but after the detectives continue to ask her and give her options for how it's possible that Hunter got her out of that trailer, first they suggest a box, they suggest trash bags, on and on and on. And finally, Megan says the trash can, which is exactly how Evelyn was found. I don't know why the closed captions says farting, because the word he used was flirting. Now, here's some lies that Megan told that we just listened to, just like not even 2 seconds ago. Hunter did not hire or interview Megan. His father did. Hunter did not own the chicken shack. His father did. Okay? So this is a confession of sorts, but I think that it's highly convenient that at no time has Hunter ever been seen in public with Megan and Evelyn. He's been seen a ton of times with Megan, but never with Evelyn. And I'd like to ask Megan this question. She said that Hunter didn't want to be seen with Evelyn because then he would go back to jail. Let me ask you this, Megan. If that were true, why in the actual F would you allow that man to spend the night at your home with you and your daughter? Why? Wouldn't there be a follow-up question that you would ask that guy after he made a statement like that? I mean, maybe I'm crazy. Maybe I've just been doing true crime too long and I just side-eye everybody needlessly. I'm just too skeptical, too jaded, and something is wrong with me. Maybe it's me. Am I the problem? Because I really do feel like if somebody says to me, and I don't really give, at this point, I don't give a rat's fat kneecap that who it is, whether it is a male or a female. If somebody says to me, if I'm seen with a child out in public, I'm going back to jail. I'm going to ask some questions right after I remove myself from that person's presence. Period. And the end. But maybe I just have problems. Maybe I'm just too jaded. All right, here we go. Let's keep going. And when we're done with this part, the jury, the case has been given to the jury for deliberation. Now that I remembered that I left that tab open and the music is playing, I know where it's coming from now. The next pause should be way smoother. Here we go.
And tell me what happened. You were on a date Monday night, Tuesday. Tell me
I don't
about
remember the day. I really don't.
whatever day, whenever you say the first day after the application that you, the first time you met him, you started working, which that we know that's on a Monday. That's easy. Y'all started flirting at work. Did y'all go out Monday night, that first night?
No, I don't remember what night we went out. I'm just being honest. I really don't.
Okay. But at some point, he started staying with you at the camp, or at the trailer.
Just one night.
He stayed in one night. And then you said he stayed a couple of nights.
I didn't say that.
You said he had slept together.
Just the one time.
Said y'all had slept together in the bed with her between.
Me and him.
Not with her.
She slept in between us.
And so I'm saying, you said you'd done that a couple of nights and
No, I said I've done it 1,000 times where she slept with me. Like her whole life, she slept with me in bed.
And then the one night he stayed was the first night he met her, correct?
I mean, no, he'd seen her like in the car with me at the chicken shack.
Okay. Like a couple days.
Megan, they're asking you when he met her, not when he saw her. I mean, technically, if you showed him a picture of Evelyn on your phone, in your wallet, on your iPad, then he would have seen Evelyn. He's talking about meeting her, being around her physically in their presence. Stop playing with these people, Megan. See, this interview gets my blood boiling all over again. Let me be quiet. I'm out of control. I can hear it.
When you went to get the application, when you applied with Bailey.
Mm-hmm.
And
I came to measure the parking lot. They wanted it redone, and I had her in the car with me.
when was that?
I don't know a day.
But you told these guys the other day, y'all went through a timeline. I think I wasn't in there. But y'all went through a timeline.
I don't remember what day I measured the parking lot. I really don't. The day they opened, I came back to the drive-thru after I left, and she was in the car with me too. In the back seat, in her car seat. The pink and gray one you all have.
Mm-hmm. Do you think he took her in that trash can?
I don't know, but it was gone. I never wanted to know.
And that's the only two places.
I don't know where else it's closed. I think my dad owns those storage units across from the trailer. You know what I'm talking about?
I do. Does Hunter have a storage building rented from him or something there?
No, but I mean,
Or do you?
no, they're abandoned.
If your family has a storage unit or owns a storage facility, and Hunter doesn't have a unit there, how in the actual F is he going to get in there? Stop this bolt loaning immediately, ma'am. But this is the interview. Let me just stop talking about what the lies Megan said. We all know she's a lying liar face who tells lies. We all know this interview is full of cockamamie baloney. Let me just play it for y'all because this is the interrogation. This is the statement that Megan gives that explains what happened to Evelyn that the defense attorney wants y'all to believe or the jury to believe. Here we go.
What would he put the baby in there?
I don't know. You are asking me guesses. I'm giving them to you. He likes the lake a lot.
Does he have a boat or anything like that?
He used to.
When you talk about the boat dock, you mentioned boat dock. What do you mean by that? Does he own a boat dock or?
They're behind his dad's house. If you go to 217 Sandy Point Drive and look in the backyard, there's 3 huge ass boat docks. I promise you, you will not miss them. They're wide.
And that's
Have you
one.
been to that house? Do you know what I'm talking about?
I did.
Okay.
But of those 3 huge ones that you have, which,
I don't know.
where would you think?
I really don't know, to be honest with you. The only thing I think of is maybe put her in the lake or something.
Do you think you would walk in from there and walk down to the lake?
What do you mean?
What do you?
There's no water there right now.
Well, that's what I'm saying. You would have to walk down the dock and walk to the lake.
Well, you can get to the lake not too far from my trailer. Because it was Lakeview Mobile Home Park before my
Is there a place you can drive down from there?
I really don't know, to be honest. Isn't there like an access, something on Sugar
That's
Hall?
what I'm asking. I don't know. There is. You're talking about the ramp, the new ramp they built down there? There is. You talking about the one on Sugar Hall, or you talking about the one on the Rock Bridge? Just before the bridge. They built a new ramp down there?
Oh, I didn't know that.
Okay. Which one are you talking about on Sugar Hall?
Well, I just passed the one that's just Sugar Hall access part.
Okay.
Thank you for letting me talk to my mom.
You're welcome. Let us put this baby in red. Okay? You come off that part. Alright, we talked. This is,
Those are the only places I know for you all to go to work, I swear.
you're positive.
Positive.
Because, listen, you,
Those are the only places you can
so
get there.
you're telling me all these other stories that you've told me. All those before, those are lies. But this is the truth.
This is the God's honest truth.
Okay, that timeline, all the dates that you gave, all that stuff prior, and all that stuff was made up. And you want, why do you want to come clean now? What benefit do you have?
I don't, but you talk to me. You don't honest with me.
Is it for me or is it for your baby?
For my baby, but you're the one who were like, hey, like, it's been going on long enough, you know what I'm saying?
It's time to put an end to it. You have no idea.
I told you the only place that I think you could have went in that short time frame.
I'm going to step in here. I'm going to try to look in the map for most places.
Can you bring me a map and I'll try to mark on it where I think?
You agree, baby? All right, well, I'm going to grab a chair. Here we got some maps. Let's see here. We got that one. We got this one. Okay, 543 Muddy Creek. Is that his dad's?
No, that's not. This is his dad.
Okay, so we got 3 maps here. So here, just take this and hit you. I know they're kind of small. This is where, that's where you were staying, I think, right? That's
Yeah, this is Buffalo Road.
okay, this is Sandy Point Street.
Yeah.
This is Muddy Creek Road. And this is where your trailer was, right? Is that right there?
Well, where's the access part of Sugar Hall Road?
So,
Is it right here?
you got Sugar Hall Road, and you should have the Ball Bridge here.
Maybe there's Sugar Hall Road away. Okay, so right across from here, there's like a storage building, like going back up towards that, whatchamacallit.
But you said those are empty, right?
Yeah.
And who own those?
I don't know.
Okay.
I thought my dad might have gone this earlier.
You just mark wherever you think, like I said, you mentioned that he had just a limited amount of time.
Well, those are the only places I think on this map.
Okay,
that
but
really
then
want
you
to
just
see.
mark where,
This is like the storage unit.
and is that for both of them?
That's an access part of Sugar Hall.
Where's his dad's house? Is that here?
Yeah. Well, I don't know anywhere else except for there and Muddy Creek.
Okay, well, just mark that, mark what that is, both dots. Put your lakes down. Is his,
So I just put Randy's house.
yeah, that's fine. Anything else you can think of? And if you don't care, just mark, I don't think storage. I think from what you're telling me, if she's in one of these two places, so just write what she was wearing if you don't care. And that's just whatever, what'd you say her clothing was? Was it her little jumpsuit, purple fleece? And a sleeper, or was she wrapped up in a blanket? Now notice, hey, this might be hard for you. Write down how she was. Her eyes open. Just like she was sleeping, right? No bloodshot, but they were open. She was warm. And all her color was there. She wasn't blue or gray or anything like that, right? Okay. All right. And that would have been 1st of December. Okay. Is that right? Like the first week?
Second week, probably.
Second week. And that's December. Anything else you can think of? Anybody else you think Hunter may have told his best friend, I'm just asking, you may or may
The
not.
only person I know that he's really close to is his mom.
Do you think she knows anything?
His mom would defend him like to the end of the earth.
Okay.
Because I know exactly he's gonna be like, well, I didn't have anything to do with that. He's gonna go back to jail, and his mom will like sit and support him on whatever the hell he says to her.
What else has he been in jail for?
I don't know.
Okay.
To be honest with you, I don't.
All right. Let me go out here. Do you need to leave, or do you want to hang out here? What do you want to do?
Well, I can't leave.
Huh? Why not?
I figured you all were going to arrest me after I told you.
For what?
For withholding information.
Why would we arrest you?
For withholding information, impeding an investigation.
Well, here's how this works. And again, I'm not talking to you much, but I need you to understand. Number one, I need you to understand that I'm not going to lie to you about anything, okay? That's not what I'm in the business of doing. I need you to understand, too, that we confer with the DA's office, okay? Before we make any kind of decision like that, that's out of our hands. But I need you to understand that I can help you, okay? You've not helped yourself at all during this whole ordeal. You know that. You're not done. No way in shape or form are you done, Maggie. You're smarter than this, than what you've let on. You have lied repeatedly, more times than we. And to be honest, didn't you go on the news last night and say that TBI? Who? You go on the news last night and tell that TBI's not doing our job. You've been up here 100 times. How many TBI agents you see running around? How many Sullivan County investigators you see running around? How many FBI agents you see? We are breaking our backs to bring her home. Then you go out there and do that. That bothers us. But again, we're not in it for anything but to get and bring her home. And you hold the key to that. So with that being said, we're the only ones that can help you. And what I mean by that, and I want you to hear me out, what I mean by that is that when we talk to that DA's office and they say, hey, what did she, well, they're going to say, hey, because we have talked to them, we know she's lied for 6 days now, 5 days, whatever it is. I haven't seen them. Many of us have not seen a full night's sleep in well over a week because of this. But when they go to and say, hey, what did she tell you other than the lies? Because how many lies have you told us? How many? Dozens? Just say it. Let me help you. I'm here to help you. How many lies have you told us? A lot. Every day you've talked to us, right? I need to go to him the DA and say, look, I get it, she lied. She was a scared mother who didn't know what to do. Okay? But today, when he and I were in here and talked to us, when you first talked to him, she started to tell us the truth. That truth is what's going to be able for me and him to go to the DA and say, hey, we know she told all these lies. She's telling the truth now. We can help her. We'll go to bat for her. And that's what we're willing to do, is to go to bat for her. Regardless of how many lies you told, we can start over right now. And I can go to bat for you and say, hey, look, she was scared. We just need to bring her home. Hey, you need to help us do that. This is a start. But you should, again, you just need to understand my perspective. You've been lied to before. How did it make you feel?
Bad.
And that was over probably something trivial. A boyfriend lied to you about going out with a girl or something like that. We're trying to bring her home. Dozens of guys out here and women out here, and in Quantico, Virginia, Nashville, Tennessee, and Atlanta, Georgia, are all working this thing. That's all we're working right now. To bring her home. Help me tell the DA she was finally the key that brought Evelyn home. I need you to be honest with us. Can you be honest with us?
I am being honest with you.
Is there any place other than here that she is that you know of?
Not that I can think of.
Okay. Anything else you think might be important? Anything else you want to tell us? Okay. Where do you want to go? What do you want to do?
I mean, I can't go to
You're not under arrest. I say all that to say that to be clear. You're free to go. Just you tell us if you want to hang out here, that's fine. We'll continue to help you out. But again, the lies are over. We can't help you unless you tell the truth.
I am telling the truth.
Okay. Tired?
Can I just stay here?
Yes, if you need anything, you know, come in the door.
Is Angie here?
Who?
Angie?
She is.
Can I stay with her?
Yeah. Want to sit with her in here?
Can I stay with her in her office, or do we have to sit here?
You'll be fine. Just sit tight. You've got food here, is that okay? Is that right?
Thank you.
And there you have it. The lies you tell, Megan. Let me see. What else was I going to say? I thought I had something else to say about the lies that she tells, but apparently it has escaped my brain. All right. So I'm going to go ahead and let y'all go for this evening. Now, keep in mind, the jury has been deliberating a total of 45 minutes now. I will keep an eye on the jury deliberations. As soon as this stream ends, I will schedule a live for the verdict. Okay. Just set your notification. Like I'll set it for, I don't know, the latest time it'll allow me. But if you set your notification, as soon as I go live, you'll get notified. All right. And we'll watch the verdict together. All right, y'all. Thank you so much for being here today. Do me a favor. If you haven't, give your girl a thumbs up, thumbs down, whichever one y'all feel that I deserve. I have a feeling it's 4:00 now. I think that they're probably going to be deliberating at least until they order dinner, which is usually around 5:30 or 6 Eastern Standard Time. So, but it could be earlier and it could be longer. I don't, if let's say they return a guilty verdict on the murder charges, I think then what will happen is the state and the defense both will be prepared to present evidence for sentencing. And I would imagine that the sentencing would be, if the verdict came back today, sentencing would most likely be tomorrow. Okay. I'm not sure though. I'm not 100% sure. Sometimes they put it off. We'll find out. But anyway, thank you guys for being here. Keep an eye out. Make sure you turn your notification on for the next stream so y'all be notified when the verdict comes in. Have a great rest of your day, and I will see you all later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious.
Finish her.
Minutes later.
We all do a little math sometimes.
And you know this, man.